Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard.
Good afternoon and welcome to the Appellate Division. I'm about to call the calendar and I'm going to ask you for the time that you were requesting for oral argument. One of the things that I've noted since we've become live and in person is that everybody's anxious to be back in court. So we have over 7 hours of requested argument time right now. And I'm going to ask you when you get up if you could please at least keep your requests down to what you reasonably need so that we can accomplish our tasks here this afternoon. Okay, the first case is People versus Anthony Lopez. All right, I'm going to give you 5 and 2 and 5. Sen Yang versus Davis. There's no cross appeal on that, so I'll give you 5, 2, and 5. All right, thank you. Matter of Tussaud L. Mark that submitted. Core Development versus Spaho. There are 2 cases, and we will hear them at the same time. Do we have a respondent? All right, so the respondent I'm going to mark submit. I'm going to give you 5 minutes on both. Okay. People versus Lantigua. And People versus Carlos Alvarez. What I'd like to do, these 2 cases which were tried together have many overlapping issues. And while we have 2 counsel for each defendant, as is proper, I'm going to hear the arguments together. I'm going to let the defendants argue, the appellants argue sequentially, and then the people can respond all at the same time, in which case I am going to give you, I'll give the appellants what they requested, Lantigua 8 and 2, Alvarez 4 and 2, and I'll give the people collectively 6. New Chapter versus Carambellas.
Appellant requests 6 and 2 with respect to both orders being appealed. Respondent requests 5.
5, 2, and 5. People versus Pinzon Cortez. Cortez. Submitted. People versus Travis W. Submitted. Montague versus T&W Restaurant. 5, 2, and 5. Thank you. Spicer versus Garter World Consulting.
Appellant request 8 and 2.
Respondent.
Respondent request 7.
I'll give you 6, 2, and 6. People versus Fontanez. Submitted. Rayengard versus KSSNY Inc. You're the respondent? Do we have an appellant? All right, so we're going to mark the appellant submitted, and I will give you 5 for the respondent. Hutchison versus Kirsch.
Yes, appellant request 9 and 3.
I'll give you 6 and 2 for the appellant and 5 for the respondent. People versus Givens. That will be submitted. People versus Minaya Rodriguez. Respondent. I'll give you 4, 2, and 4. Pedraza versus New York City Transit Authority. I'm sorry, I didn't hear you. 8 and 5. You want to argue them together? For Pedraza, you want 5 and 2. Okay. 5, 2, and 5. I am going to have them separate because there are some different issues in each one of them, and they are different plaintiffs. So on Martinez, what are you requesting? That probably doesn't need as much, but I'll give it to you. 5, 2, and 5. Pritzker versus Szymanski is submitted. All right, first case on the calendar versus People versus Lopez. Step up, please.
May it please the court, my name is Chloe Surinsky, and I represent appellant Andy Lopez in this matter. And if your honors don't mind, I'd like to start with point 2, which is the on-the-record misadvice claim.
You may.
Thank you, Your Honor. In this case, at the plea proceeding, the court asked defense counsel a very clear question: what are the immigration consequences of this plea? And counsel gave a very clear and very clearly incorrect answer, that there are none. This is incorrect.
Well, the response was there are no immigration consequences.
I'm sorry, I didn't hear you, Your
The
Honor.
response by counsel was that there are no immigration consequences.
That's correct, Your Honor.
Now, we know that this was incorrect because we know that at the initial arraignment, the defendant, through his counsel, was given the immigration sheet, the sheet showing deportation and immigration, right? So the defendant already knew of his immigration status based upon that. So I recognize that your argument is that there was misinformation by counsel on the record, but how is this misinformation relevant given the fact that the defendant was already given notice of his negative immigration status?
Sure, Your Honor. And this touches in part on the Peke issue, but the record doesn't show that the defendant was actually ever handed the notice. In my review of the record,
But the notice was given to his attorney. So if the notice is given to his attorney, therefore the conclusion is that it was actually given to him.
right, Your Honor. Also, in my review of the record, and the people haven't produced the notice of immigration consequences, I didn't find it. We don't know if it references deportation. We don't know if it references the actual plea of conviction. But more importantly, there are a number of cases by this court where it discussed this issue of, oh, you know, is there no prejudice because there was a notice of immigration consequences?
Well,
First of all, this court...
We're probably going to inquire in the same thing. Does the issue of prejudice, I mean, even if you're right that this was misadvice, then we still have to deal with the hurdle of prejudice. And the question is, given the prior robbery conviction, where there was mandatory deportation, does that have any impact on an argument about whether there could ever be prejudice here, for at least this misadvice?
Yes, Your Honor. There's a few things. First of all, in the record, we don't know. We have the statement of predicate felony. We don't know what the sentence is. So even as a lawyer, I can't assess what the immigration consequences would be. More importantly, prejudice is something that should be, as this court has held, should be developed at a hearing. The inquiry about prejudice is what the defendant would have known or would have done but for his counsel's misadvice. We don't know what the defendant here knew. We don't know if he was misadvised about the earlier plea. We don't know what the immigration consequences were.
So, counsel, is the necessary consequence of that argument that there must be a hearing in every single case where these circumstances arise?
I believe if there is very clear on the record misadvice, as there is here, and I know that there was the James case where this court found an exception to the general rule that prejudice should be developed at a factual hearing. Those were circumstances that were incredibly clear.
But we didn't have the notice of immigration consequences in the James case, and we didn't have the prior conviction for robbery in the third degree in the James case.
In James, at the plea hearing, the people said he will definitely be deported, and the court said he would be subjected to deportation. Here there was no paquet warning. We don't know what the notice of immigration consequences said. And this court has found in Corporan that even when the court at the plea hearing has given a correct paquet warning referencing deportation, where counsel undermines the court warning by understating the potential for deportation, you need to remand for a prejudice.
Well, that's the question. Did counsel actually undermine that, again, based upon the prior conviction and based upon the notice of immigration consequences? And I recognize you're stating that there's no copy of the notice in the record. However, the people stated on the record, I am serving counsel with notice of immigration consequences.
May I quickly respond, Your Honor?
You may.
The crux of paquet is that the defendant needs to be told about the deportation consequences of the plea. We don't know if it was done here, but this court has held time and time again in Corcoran and Picaro and People v. Patrick Johnson that even where there is a notice of immigration consequences, that doesn't eliminate the need for a prejudice hearing. Prejudice hearing is where a defendant can appropriately develop what he knew, what he didn't know, what he might have done. And I believe the same would go for the prior conviction. We don't know what he knew based on the record. I don't even know what the immigration consequences of that conviction was. So I believe that it's appropriate to remand it for a prejudice hearing.
Thank you. We'll hear from your opposing counsel.
Good afternoon, Your Honors. Julia Gorski for the People. I just wanted to correct the record quickly. Both the pre-sentence report and defendant's rap sheet reflected that for the 2015 robbery conviction, he was sentenced to 1 year incarceration, which qualified that offense as an aggravated felony under federal immigration law, which rendered his deportation mandatory.
But counsel argues that how would the defendant even know that, or how do we know that he knew what was contained in the pre-sentence report? And, well, that was after the plea. But how do we know that he knew what was contained in his rap sheet prior to his entering a plea of guilty?
He was served with a notice of immigration consequences, and the notice of immigration consequences is a standard practice from our office, and that specific notice of immigration consequences was specifically upheld in People v. DeLorbre.
But it's lacking in the record, in that there's no copy of that in the record.
I have no idea why it did not end up in the court file, but as reflected on the record, the people did hand the notice to defense counsel in open court, and there is a record of that. And again, this is a standard form that our office serves all the time and was upheld specifically in DeLorbre. Because that notice was served on defendant in open court, the preservation requirement was triggered for his PECE claim. Because he did not preserve it, it is unpreserved, and a hearing is not the proper remedy on appeal. The court shouldn't reach the defendant's PECE claim in the interest of justice either, because as your honors have hinted to, he could not successfully establish prejudice because his deportation was already mandatory as a result of the 2015 robbery conviction. Moving to the—
Counsel, the second department, in some cases cited in the reply brief of the defendant, seems to have a more liberal point of view about prejudice, that even if there is a previous conviction with immigration consequences, that still sometimes it's appropriate to send back the case at hand to a hearing. So that's PICA. I think in Saunders they just granted the 440 motion. That's another second department case. Why shouldn't we take that point of view as well, in that we don't know the subjective thought processes of the defendant?
Your Honor, under the circumstances of this case, remand for a hearing is just a hollow gesture. It is clear that the defendant has already been, although it's not part of the record, his current rap sheet reflects the fact that he was deported in 2019, and because he has already been deported before this current appeal has been resolved, the logical inference is that it was because of the 2015 robbery conviction. So this is something that's logically inferable from the record, and although this is not part of the record,
why is that logically inferable?
Because
you know that ICE waits until the appeal process is done before they deport? I'm not aware.
That's correct. The Board of Immigration Appeals has held that a conviction cannot trigger actual deportation until the defendant has resolved his appellate process. So here, because we are currently on the appeal discussing it and the defendant has already been deported in 2019, he was not deported for this instant offense, and therefore cannot establish prejudice as a result of any error that he claims on appeal.
So your argument is that obviously he was deported pursuant to the 2015 conviction?
Yes, and the district attorney did reach out to ICE, and although it is not part of the record, it was confirmed that he was deported because of the 2015 robbery conviction out of Bronx County. So because the PECE issue is not preserved and because the record as is does not establish both Strickland prongs, the Padilla issue should not be resolved on direct appeal because he cannot establish prejudice, and the proper remedy for defendant is filing a 440 motion to expand the record and actually discern what defense counsel had told him about the immigration consequences of his plea. And for those reasons, the people ask that you affirm. Thank you.
Thank you. Rebuttal?
Your Honors, I want to address a few points. The people refer a lot to matters outside of the record and matters that happened subsequent to the plea. This court in People v. Gaston held that the relevant inquiry for prejudice is the time of the plea and what the defendant knew at the time of the plea. And we haven't even had a prejudice hearing here. Statutorily, CPL 44010 precludes a 440 motion if there's evidence sufficient on the record that it could.
Counsel, as a practical matter, how would you be able to establish prejudice given, again, the 2015 conviction, the notice of immigration consequences? How would you be able to, and also given the the plea agreement, which inured to your client, which was rather generous given his priors. So how would you be able to establish prejudice?
Sure, Your Honor. With respect to the prior convictions, we're not looking at this as what an attorney might have correctly analyzed about the defendant's position. It's about what the defendant knew. We don't know what he knew. He could have been misadvised with respect to that earlier case. The PSR, as Your Honor correctly mentioned, postdated the plea. The rap sheet was not in the record that I could find. But the Second Department cases that I've cited state that prior convictions, even when they certainly do make a defendant mandatorily deportable, are just a factor in the
No, but my
prejudice
point
inquiry.
was, given his background and given his rap sheet and given the facts of this particular case, 3 years was a rather generous offer, and it ignored a great benefit to him because it was below what he would normally receive. So I'm not sure how you would be able to establish that he would not have pled guilty but for the alleged misinformation by his attorney.
Yes, Your Honor. May I briefly answer that?
You may.
This court has held time and time again that the calculus for prejudice is simply different for non-citizens, that deportation consequences are often of primary importance, that the strength of the case in People v. Mabuan, along with a number of other cases, is not determinative, it's a factor, and these are all issues that are appropriately developed at a prejudice hearing. I don't believe we could bring a 440 motion because we have clear misadvice on the record that we're supposed to bring in the appeal. And I'd just like to correct one point that the people made. Although we're talking about a lot of issues that post-date the plea, which is inappropriate in this analysis, Bratwaite, which is the Second Circuit case that they're discussing, didn't arise until 2021. As of the time of this plea, he had no immigration detainer lodged. He was not in proceedings. We don't know what he knew. And even in cases where, this is People v. Gingery out of the Second Department, even in cases where counsel put on the record, he's in deportation proceedings because of a prior conviction. The appellate court said that that's fine. He can move to withdraw his plea if he didn't know. That is not determinative of prejudice, and prejudice is a matter that's best developed at the trial court where the people can bring in these off-the-record statements and we can bring in off-the-record evidence as well.
Okay, thank you. Thank you both. The next case is Sanyang versus Davis.
Good afternoon, Your Honors. May it please the Court. Brian Isaac. I represent the plaintiff appellant in this matter. There are two issues, as you know. One is the summary judgment issue, and one is the disqualification issue. I actually think the disqualification issue is probably a sexier issue, but let me start with the summary judgment first, because I just think it's a little easier. As you know from reading the defendant's affidavit, as I read it, his position is, I never saw the other vehicle. If you look at 105 of the record and take a look at the photographs, it's absolutely a rear-end impact. The whole rear of the plaintiff's vehicle is kind of caved in, and the right front of his vehicle is caved in, so you have a rear impact collision.
Well, but the photos also support a scenario that it wasn't a straight-on rear impact, that the rear impact was mostly felt on the driver's side, and it was on the side and the rear on the driver's side. Does that make a difference here?
It does not, because if the vehicle is in plain view, which it has to be, then there are two bases. One, too close, and two, failing to see that which should be seen by the proper use of one's senses. Justice Gish, I agree 100%. If there was damage to the side of the vehicle, that's a different story. But you can't assume that there was a cutoff when the plaintiff says, both plaintiffs say, we were in our lane and he struck us, and there's a case. It's not a Second Department case.
But we're just trying to search for an issue of fact, and didn't the photos at least show that the car was straddling the demarcation line for two lanes, at least where it landed?
After the accident, we have a tractor trailer that doesn't see the other vehicle going at 25 miles an hour. So it's not unusual that, that given the disparity of the weight between the two vehicles, you might be a little over the line or
Maybe
might be a little
so.
in the line.
Maybe so, but the question is, do we have an issue of fact? Are those photographs, can they also support the scenario of the accident that is described by the defendant?
And my answer is, post-Rodriguez against the city, no. The fact of the matter is that that driver was both negligent for failing to see the vehicle, which was there to be seen. He said there was no vehicles in front of him, nothing obstructing his view, and in striking the vehicle in the rear. If I can I just give you the cases that I want? There are two cases specifically I want you to look at. The first is Cartagena, Cartagena against Martinez. It's 112 AD 3D 521. In that case, there was a rear-end collision, and the claim was that there was a move-in, and this is what you said. Defendant's opposition fails to raise a triable issue of fact. Although defendant driver stated that plaintiff's car cut off his truck, he also testified he did not see plaintiff's vehicle until after the collision. Thus, defendant's purported non-negligent explanation for the collision was speculative. That's exactly what we have here. And the other case I'd like to refer you to is Steigelman. It's Steigelman against Trans Service Lease Corp. It's at 145 AD 3D 439 at 440. This was a case where there was a claim that the plaintiff's vehicle, quote, squeezed in on the left, and this court said that the evidence showed that, quote, Stroud, that's the defendant, was negligent in failing to see what was there to be seen, namely plaintiff's car. That's exactly the same situation we have here. With respect to the disqualification issue, I think there is a difference between the Second Department's precedent and the First Department's precedent. I cited to the disciplinary decision a matter of Ravitch. I think it stands for the proposition there's no per se disqualification rule. We have here a situation where you have a husband and wife. There's not going to be any coverage under the policy because it's a 3420G exclusion.
Yeah, but the policy is irrelevant to the conflict. The passenger may still have a claim against the driver in the plaintiff's vehicle, right?
That's correct theoretically, but in practicality here, the answer is no.
Does it matter that he was the only one that, as far as I could tell from the record, who requested immediate medical assistance and went to the hospital right after the accident?
I don't think that would make a difference in terms of the liability scenario. I'm not going to go over my time, but I don't think that makes a difference in the liability scenario. I do think that you have to be careful, obviously, with conflicts with drivers and passengers. It's always a better idea not to do it, but if you have two people who have the same exact view of the accident, the fact that there's a theoretical conflict doesn't mean that there's an actual conflict. Both plaintiff and both the driver and the passenger said exactly the same thing. Their testimony is not going to be any different. No lawyer who's worth his salt is going to tell somebody to testify differently from the facts.
Counsel, were both plaintiffs given a written waiver to execute in terms of the disqualification, any potential conflict?
So, Your Honor, I think you. I'm sorry, just may I finish?
Yes,
and I'll pick this up on my reply. There is a technical problem. The only affidavit that was submitted was from the passenger, who said that he waived the conflict. There was no similar waiver from the driver. But I would submit to you that even though there was no written waiver, this is a clear situation where you can tell from the party who submitted the affidavit that he was the one who would have been affected, and he said, I do not want to sue my wife because she didn't do anything wrong. So as a practical matter, that yes, it would have been certainly better to have two affidavits and to have written waivers in accordance with the rules of professional conduct, but I think that when you look at the evidence in its totality and holistically, it's clear that their interests are completely aligned. I'm sorry for going over my time.
Thank you. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is James Desmond. I represent the defendants' respondents, Eddie Leroy Davis Jr. and ELD Driver Service, LLC. The defendants' respondents have we submit that the lower court was correct on both counts. Number one, that the lower court was correct in denying the plaintiff's motion for summary judgment on the issue of liability and granting the cross motion with respect to disqualification. With regards to the liability component of the appeal, there's clear issues of fact here, Your Honors. that exist, which go to the manner in which this accident occurred. The defendant's affidavit that was submitted and the First Department precedent is clear and convincing, and it is no dispute when there is an affidavit that clearly rebuts the way in which this accident occurred. That in itself is enough to defeat summary judgment. In this
Counsel,
case,
the plaintiff's motion was essentially pre-discovery, correct?
there has been no discovery in this case. This was in fact, there has not been any type of discovery order in this case. So we do not, as of yet, have any depositions. This was made purely on the pleadings and the police accident report, which, as we know, is in this case made by an officer who was not present at the scene, who took statements which my client disputed from day one. He had requested that the New York City Police Department amend their report, and he provided photographs with respect to the accident scene and the observations. With regards to what counsel is alluding to in his papers, in the brief, and to this court today, my client did see what was to be seen. His affidavit clearly states that he was looking forward and did not see any vehicles in his lane or the lane to the right at the time he heard those two consecutive booms on the right. That accident, Your Honor, was not a rear-end collision. That accident was a side swipe. That affidavit shows that there were clearly questions of fact with respect to the photographs and the affidavit. As Your Honors know, the First Department clearly holds that if there's any questions with respect to credibility, as counsel is trying to maintain here today, that is for the trier of fact. So we posit that the lower court was correct in its decision with respect to liability.
And am I mistaken that the photographs of the damage, while they did show rear-end damage, also showed side damage to the car?
Well, Your Honor, the photographs, if you look at them, and this comports with the affidavit from my client, it does show that there is there's side damage. Now, the vehicle itself, the photographs that were taken do show the behind, the rear, but also shows the side, and clearly that comports with a side swipe accident, not a rear end. So the summary judgment motion that was made pre-depositions, prior to discovery, was based on the assumption that this was a rear end accident. There is no rear accident. This is a side swipe. We're entitled to have, at the very least, a trier of fact determine these issues with respect to liability. With respect to the second component of the appeal, the disqualification, as Your Honors, as counsel concedes in his papers, as Your Honors see in the record, there is no affidavit with respect to the driver. The driver did not provide an affidavit in their motion papers or in the reply with respect to any type of consent given for the dual representation.
Could that be cured? Is that a technical error? Can the waiver from the plaintiff driver be put in now, and then all bets are off on disqualification?
Well, Your Honor, I would respectfully say no. As I read the court, the precedent from the Court of Appeals in the Green decision, as well as the decisions in this court, that decision has to be made at the time of representation. And those decisions have to be made with full consent and disclosure of all the facts. As the lower court found, that was not done. That is not on the record here today. And we take the position that the lower court was correct in its decision that the disqualification is warranted here.
But as you said, counsel, there's been no discovery. You said there was no discovery order. So why could it not be cured at this point?
Why could it not? What, Your Honor?
Why could they not submit the affidavit at this point, since nothing actually has been done?
Right. So, Your Honor, an affidavit for purposes of this disqualification motion was shown that there was no affidavit that was presented in this motion. So it's not of the record. With respect to any disqualification, we maintain that the record establishes clearly that there was no consent by the driver in this case. Thank you, Your Honors.
Thank you. Rebuttal?
Yes, Your Honors, apropos to the questions that were raised in the end, we made a motion to re-argue. It wasn't really a motion to renew. Same decision came down. We didn't appeal from it because there's no appeal from it, really a motion to re-argue. And we did put in an affidavit from the other party, from the driver. Didn't make a difference in the trial court. If I can, I hear that this is a sideswipe argument, and you're all smarter than I am. Maybe I'm missing something, but if you look at 106, this is the photograph that was taken by the defendant with his car. There's damage to the entire back side. If it's a sideswipe accident, you're not going to have that kind of damage on the right side, or if you are, you at least have to have some type of explanation.
Counsel, at this stage where there have been no depositions and all we have are these two competing affidavits and pictures that can be interpreted in your opinion one way, in others' opinion a different way, why aren't these issues that should then go to a jury?
Well, there are a bunch of recent, if I can, I don't believe my adversary raised prematurity as an argument, but I understand it's a concern of the court, so let me address it. Where you have two people who know of the accident, and they know what happened and they were there, the argument that you didn't have discovery doesn't necessarily provide a basis to forestall summary judgment in the CPLR 3212F, because the Court of Appeals held in the Auerbach case, the Auerbach against Bennett case, as you know, that a hope that something will be uncovered during cross-examination is insufficient. And my position is that this can be decided just on summary judgment burden shifting. We made a prima facie showing the defendant's affidavit under Stiegelman and DeVito is insufficient. You don't have to go any further. If there was a fact that wasn't discoverable, if there was a witness who was there who said something different, that's a different story. But just to say that you didn't complete discovery or the case is at its inception doesn't really mean that you shouldn't get summary judgment in the context of moving cases. I see my time is up. Thank you for listening to me.
Thank you. The next case or cases for argument or court development versus Spaho. You can proceed, Counselor.
Thank you, Your Honor. Good afternoon. May it please the court. My name is Nathan Zazula. I'm the attorney for plaintiff appellant core development in both cases. I'll start with 4858, which I think is the simpler argument. In this case, the plaintiff is appealing the dismissal of a single count of conversion. As I'm sure the court is aware, there's a liberal pleading standard in the state of New York. A complaint should not be dismissed as long as the plaintiff is given the benefit. The plaintiff must be given the benefit of every possible inference. Also, on the test, the test is not whether the plaintiff has artfully drafted the complaint, but whether deeming the complaint to allege whatever can be reasonably implied.
Yeah, we certainly know that standard in terms of a pleading. I guess here on the cause of action, and this is where I had a question. One, the court seemed to be concerned that you didn't produce a demand letter. Were you required to produce it on a pleading motion?
Your Honor, the court did point that out, but it also acknowledged that at this stage of the pleadings, if there's a statement in the complaint that there's a demand letter, at this stage of the pleadings, that's enough. Certainly.
Right, and you had that statement in the pleading, did you not?
Yes, Your Honor.
Okay, and the other thing is conversion. The court talked a lot about ownership, but is it your position that while ownership might lead to a claim of conversion, that really what conversion is concerned with is the superior right of possession?
Yes, Your Honor, both are required. So we have statements throughout the complaint that I've cited to in the papers of clear statements of ownership, and then clear statements that the plaintiffs were not able to use or have access to this property because of the defendant's refusal to give them access.
All right, and what about the unjust enrichment claim in the second part of this case, or the second case?
The second case, yes, Your Honor.
Yeah.
I'll move along. So, Your Honor, in the second case, we're appealing the dismissal of the three related claims: breach of contract, covenant of good faith and fair dealing, and unjust enrichment. To address the question first on unjust enrichment, the court essentially seemed to dismiss this claim, first of all, because they found there was no contract, and second, they found it to be duplicative. And in our papers, we argued that this unjust enrichment claim is cited in the alternative. It's pled as such, and this
But
is...
if there's no contract, you can't have unjust enrichment, right? That's a rule of law, right?
Yes, Your Honor.
If you can sue, you don't get an equitable remedy if you have a remedy under the contract.
Right, and that's the court, when they found there was no contract, they dismissed the good faith and fair dealing claim as well as the unjust enrichment claim also. So the kind of the crux of the issue in this...
Well, the fair dealing, you have to have a contract to
Yes, Your
get the covenant of fair dealing, right?
Yes, Your Honor.
I mean, they're kind of, one is dependent on the other, right?
Yes, Your Honor.
So if there's no breach of contract that is alleged, then there's no breach of the covenant of fair dealing. Would you agree with that?
Yes, Your Honor, I would.
Okay, so why was there a contract pled?
So the contract is an oral contract that's alleged. And really quickly with the facts, the way this contract came about, there was an IRS audit in 2014. And pursuant to this audit, the plaintiff discovered that the defendants couldn't account for some $500,000 in revenue. In essence, the till was light, $500,000. They did an investigation internally, and they discovered, yes, even though the financials of the company didn't show this, there was a $500,000 missing, and the investigation also showed that there was an application to Wells Fargo for a loan in which the defendants stated that this money had been collected. And again, this is an application that says things, that the people that sign this are affirming that these are accurate statements, and there's a list of horribles, if you lie on this application. So they confronted the defendants with this shortfall. The defendants admitted that there was a shortfall, but blamed it on money not being collected. So that you have the defendants saying the money wasn't collected, but
Yeah, I think we're familiar with this. I mean, this is all in the record.
Yes, Your Honor.
And you don't have an adversary here, but I gave you 5 minutes, so if you could get to the salient point, and then we'll conclude and decide the case.
Yes, Your Honor. So the salient point is that there was an oral agreement to pay the money back. It wasn't an agreement to collect the money, it was to pay the money back. In most oral arguments, it's a he said, she said. In this case, we have an email that references a promise. It references a promise to make good on funds, even if those funds aren't collected. So we have an oral argument, and then we have an email which references that argument, and that's the basis of the contract, Your Honor.
All right, thank you.
Thank you.
The next case for argument is two of them, People versus Lantigua and People versus Alvarez, which will be argued together. Whenever you're ready, Counselor.
Good afternoon, Your Honors. Victoria Wu, Office of the Appellate Defender for Mr. Lantigua. I would like to address both the weight of the evidence and the double jeopardy issues, and if I may, I would like to begin with the mistrial issue. The trial court in this case erred by ordering a mistrial without prejudice when Mr. Lantigua specifically requested a mistrial with prejudice. In matter of Davis versus Brown, the Court of Appeals specifically held that a defendant may move specifically for a mistrial with prejudice, and it identified the actions that a trial court can take in response to that kind of motion.
Okay, so counsel, here, defendant did not consent to the mistrial. Is that correct?
That is correct, Your Honor.
So in order for it to be without prejudice, then we need manifest necessity, right?
That is correct.
Is there manifest or was there manifest necessity?
There was no manifest necessity here because, as the prosecutor herself pointed out before the trial court, the evidentiary error that sort of prompted the mistrial motion could have been remedied by a curative instruction, and on this appeal, our respondent has not argued otherwise. The curative instruction is the standard remedy for dealing with evidence that the prosecutor has failed to provide sufficient notice, and that was later admitted at trial.
So would the curative actually have been able to cure that? I mean, would the instruction actually have been able to cure that? The testimony was that she met with the assistant district attorney on numerous occasions. I think she met 4 or 5 times. And also, the assistant had shown her photos of individuals related to the case, and that I think the detective had also shown her a photo of the defendant's arrest, the defendant's arrest photo. Given that testimony, how could there have been a curative fashioned which would, in fact, ensure that there was no prejudice to the defendant?
2 points, Your Honor. One is that the jurors are routinely instructed to disregard evidence that should not have been admitted in the first place. We presume that juries follow those kinds of instructions. There's no reason, based on the facts here, that the jury would have disregarded the court's explicit instruction to disregard the evidence that was improperly admitted. And secondly, the prosecutor pointed out in the trial court, in response to the mistrial with prejudice motion, that as to Mr. Lantigua, the prejudice was somewhat minimal because it was undisputed that he was the driver of the car. So the evidence that is at issue pertained to identification, and the trial prosecutor said that, look, the prejudice here was minimal, a curative instruction would have been appropriate. So based on the people's own argument below, it is clear that there was no manifest necessity to...
But although Mr. Lantigua was the driver, the alleged driver of that second vehicle, there was still an identification of him by the witness. So why would there still not be some prejudice to him, potential prejudice to him, based upon the identification procedure and lack of notice of the same?
Well, I think the prejudice from the improper evidence would have been fully cured by a curative instruction by the trial court. Again, that happens every day in trials. Courts routinely admonish juries to disregard evidence that it erroneously admitted. There's no reason to believe in this case that the jury would have disregarded and violated the trial court's instruction. The people's position below was that the court should have given such a curative instruction. The court simply did not explain why it disregarded the prosecutor's own recommendation. And again, respondent on this appeal has not argued that manifest necessity necessitated a mistrial. And so the issue here really is whether Mr. Lantigua consented to the mistrial without prejudice. And in light of the Court of Appeals' decision in matter of Davis versus Brown, the Second Department's decision in Romero versus Justices of Supreme Court, it is clear that when a defendant specifically moves for a mistrial with prejudice, that establishes that he is not consenting to a mistrial without prejudice. The trial court's decision in this case to order a mistrial without prejudice violated the Court of Appeals' decision in Davis, and that is reversible error that requires reversal of the conviction in this case. Aside from the double jeopardy issue, the conviction should also be reversed because the weight of the evidence did not show that Mr. Lantigua shared the intent of his passengers. It is important to note that there was no evidence in this case that Mr. Lantigua knew any of his passengers, that he knew what their intent was.
But counsel, he did follow Mr. Rendon's, the complainant's Voyager, his minivan, for several blocks, did he not?
He did, but he was a licensed for-hire driver, and so this record also supports the inference that he was simply following the instructions of his passengers.
And then when they jumped out and went to the vehicle that was in front, he waited, right?
Right, but witnessing an incident doesn't mean that one intends to take part in it. Again, he was a licensed for hire driver.
Didn't he circle back also, come back around? And so, didn't he circle back or come back after they had jumped out as well?
No, I believe that the testimony was that he was behind the vehicle of the complainants, and then after the passengers came back, he made a U-turn.
Right.
Right, so I think it's very
A
reasonable.
sharp U-turn to the point where the car almost tipped on the side, right? That was part of the testimony?
I'm sorry, Your Honor?
That when he took off, after they jumped back in the car, he took off and made a sharp U-turn to the point where the car kind of tilted. That was the testimony of some of the witnesses, right?
Right, and I think it's consistent with the fact that in the moment, he probably froze and panicked and just did what his passengers told him to do.
So you're an Uber driver. I don't know whether he was a livery cab. You're claiming that he was a livery cab or Uber or whatever, just for hire. So once he sees these individuals jump out of his car, go to another car, there's some interaction with that car, then because he's for hire, he's going to, although that may look a little suspicious, he's going to make a U-turn and come back for them?
No, I think he stayed where he was behind the complainant's car, and when the people came back, he then made a U-turn. So again, I think it's consistent with the fact that as a licensed for hire driver, he was following the instructions of his passengers, and he probably froze and panicked in the moment. I mean, no one expects to see a robbery unfold
But
like that.
he's charged with acting in concert, right?
Yes, correct. So in order to prove guilt in order to obtain a conviction, the prosecutor had to show that Mr. Lantigua had the exact same intent as his passengers. And on this record, it's simply not possible to reach that conclusion. Again, there was no evidence that he knew of his passengers. There was no evidence that he knew what their plan was. There's no evidence that even if he knew what the plan was, that he approved of them. There's no evidence that he knew any of the complainants. And he had no motive to participate in a daytime robbery because he was a licensed driver. Why would he sort of jeopardize the way in which he was earning his livelihood to participate in such a robbery? And so for all these reasons, for both the weight of the evidence issue and the double jeopardy issue, the conviction should be reversed and the charge dismissed.
Thank you. All right, let's hear from the appellant in Mr. Alvarez's case.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Carlos Alvarez. May it please the Court. I'd like to get back to the question raised by Justice Weber. Was there manifest necessity? As you know, the people have not argued that there was manifest necessity warranting a mistrial here. Therefore, we did not have occasion to address it in our briefs. But there is case law that says in the case of prosecutorial error, it is up to the defense to choose whether to accept a curative instruction and go to a verdict with the jury they have chosen or to accept a mistrial. That's a defense choice in the face of prosecutorial error. And I'd be happy to submit additional briefing on that, a post-argument submission. But if in the case of prosecutorial error, the double jeopardy clause protects the defendant's choice. The defendant is invested in the jury they've chosen. They've midway through trial, they may want to choose to go to a verdict with that jury with the appropriate limiting instructions, or they may want a mistrial. That's because it's prosecutorial error. That's a choice that the defense gets to make under these circumstances. And there was no choice posed to the defense here. There was no unequivocal acquiescence in the mistrial, so therefore there was no consent.
So, counsel, you said that the people are not arguing manifest necessity, but don't we have to reach that issue? Because you did not, the defense did not consent to the mistrial.
Well, if the people are conceding there was no manifest necessity, there's no issue really joined there.
So then there's no issue on appeal, right?
There's no issue on appeal as to whether there was manifest necessity. They haven't argued there was manifest necessity. Their argument solely is that the mistrial, that the defendants consented to the mistrial.
So is there anything in the record that I understand the first day it was counsel moves for a mistrial, and then it wasn't any statement, I don't think, as whether it was with prejudice or without prejudice or on consent. And then the second day, the attorney came back and said, with prejudice, we're not consenting. Is that correct? And then I think the co-defendant joined in the application.
That's correct.
So is there anything that would lead us to believe, based upon that record, that it was with consent?
There's nothing to establish consent. In Davis v. Brown, the Court of Appeals said you have to establish unequivocal acquiescence in the mistrial without prejudice when counsel has moved for a mistrial with prejudice. And the failure to object is not unequivocal acquiescence. So there's nothing in the record to establish consent. Davis v. Brown is very clear in its mandate where a defendant moves for a mistrial without prejudice. That doesn't establish consent to a mistrial without prejudice. And that's precisely what happened here. Thank you.
Thank you.
Good afternoon. May it please the court. Diana Lewis for respondent, the Bronx District Attorney's Office. Your Honor, I am going to start, Your Honors, if it please the court, I'm going to start off with the issue of the mistrial. Here, the defendant, nobody specifically delimited their motion. Counsel asked
Say that
to
again,
some
I'm
degree.
sorry, I didn't hear you. Nobody specifically delineated what?
Delimited the motion to a mistrial with prejudice. What was said,
They did the second day, though.
they said to some degree. And
What is to some degree with prejudice?
he said he wanted to amend his motion to, for Diaz, said he wanted to limit his motion to some degree to a motion for a mistrial
He
with
never said he
prejudice.
wanted to limit. I don't believe he ever used the word limit. He said, I want to amend my motion. He's amending his motion and seeking a mistrial with prejudice. What limitation is he placing
He said,
on that?
well, the limitation is, he said, to some degree. But then,
Well, that is an amendment to some degree. It changed from, no specification of with or without prejudice to, I'm now asking that it be with prejudice. And that clearly was done before the judge ruled on the motion. So, I mean, that was the motion before the court. I don't know how you get around that.
And that was prompted by the court statement that next day, that noting the motion could be with prejudice or without prejudice. Without prejudice would mean that the case will be retried. If I grant the motion with prejudice, then I'm finding bad faith. And if I'm denying it, then I'll be dismissing the indictment. At that point, that's when counsel says, I'm amending my motion and seeking a mistrial with prejudice. And then counsel for Alvarez, then also joins in the motion.
however, Your Honor, when you read the record as a whole, counsel for Alvarez says there's no way you can unring the bell. There's no curative, he says there's no curative instruction that can be given that would unring the bell. So what
does that mean? So you're translating that to mean that I am moving for a mistrial without prejudice?
I'm taking that to mean he's moving generally for a mistrial. I'm taking it to mean that the defendants did not want, after hearing the evidence from the identification evidence from the female passenger, they did not want this jury to hear the case.
Well, didn't one of the counsel say, I want this jury? Somebody did say that.
Not to my recollection. The prosecutor said that the prosecutor wanted to keep the jury.
But again, counsel, you just stated, my question was, if counsel back up. You're arguing that counsel stated that that there's no curative instruction that would remedy the prejudice already based upon the testimony of the witness. Is that correct?
Yes.
So that would lead me to believe that what counsel is arguing is it's too late. There's nothing that can be done. The case has to be dismissed.
But there was no manifest necessity. I mean, there was no prosecutorial misconduct that would warrant the case being dismissed.
That would be your argument. That would have been the assistant's argument at the time. But what counsel was saying is, it is too late. There cannot be a curative instruction. We cannot save this. And based upon the misconduct of the prosecutor, the case has to be dismissed. And there was no response by the assistant at that time.
The assistant responded with a suggestion of a curative instruction in order to keep the case. The assistant also responded that this was not prosecutorial misconduct to the level where prejudice would ensue, because this was the third assistant who had the case. She didn't know about the identification procedure in the complaint room. And she had.
But counsel, let me get back to a point that was made by your adversary. Do you at any point argue that there was manifest necessity, or are you stating that there's no need, that there was no need for establishing manifest necessity?
There was no need for establishing manifest necessity.
Well, manifest necessity was never argued either.
I'm sorry, I couldn't.
Manifest necessity was never argued by the people, was it?
No.
So we're prohibited from reaching that if we chose to do so by People versus LaFontaine, right?
Right.
So our only, the determination to be made is whether it was with consent or without consent. Is that correct?
Whether they requested a mistrial generally, or whether they specifically.
I don't know what's a general mistrial. I've never, could you tell me what's a general mistrial?
Meaning with or without prejudice. And not delimiting it to with prejudice. And I see my time's up. Thank you.
Okay, we'll hear from Mr. Lantigua on rebuttals first, his counsel.
Just very briefly, Your Honors, I think you're entirely correct to point out that counsel here made a specific motion for mistrial with prejudice. So,
What about counsel's argument that it was qualified with this to some degree? How should we interpret that?
What counsel said is, I'm amending my motion to some degree. I'm making a motion for mistrial with prejudice. That is exactly what happened in the Court of Appeals case of Davis, where on the first day, the defense attorney made an unqualified motion. The next day, she came back and said, I'm pressing my motion with prejudice. This is exactly what happens in this case. Counsel at first made an unqualified motion that is on page 652 of the transcript. Then the following day, on pages 662 and 667, 668, counsel then amended their motion to make it a motion for mistrial with prejudice. So this clearly falls, this is exactly the same scenario as Davis. And Davis teaches that in that circumstance, a trial court cannot order a mistrial without prejudice, because by making a specific motion for mistrial with prejudice, the defendant is withholding his consent to mistrial without prejudice. Respondent's argument here flies in the face of the Second Department's decision in Romero. As I mentioned, Romero is on all fours with this case. There, the Second Department rejected the notion that if a defendant makes a mistrial motion with prejudice, that somehow one can infer consent to mistrial without prejudice. Clearly, there's a difference between a motion for mistrial with prejudice and a motion for mistrial without prejudice. The two are not the same thing. So the respondent's argument here to suggest that by making a motion for mistrial with prejudice, the defense somehow consented to a mistrial without prejudice is illogical and contrary to Davis and Romero. And so for that reason, the conviction should be reversed. Thank you.
Thank you. Mr. Alvarez's attorney.
Thank you. So coincidentally, 26 years ago, I represented Mr. Davis in the Court of Appeals before I had these reading glasses, so I have inside knowledge about the applications that were made. And it's the same case. It's the same situation where in the afternoon, the defense lawyer asks for a mistrial generally. The next morning, the lawyer comes in and says, I've rethought my position. I want a mistrial with prejudice only. And it appears again and again on this record at page 670.
Counsel, just to be clear, it's not, I want a mistrial, I'm moving for a mistrial generally. It's, I'm moving for a mistrial. There's no generally. Did we not say that?
That's correct.
Thank you.
First day, lawyer said, I'm moving for, the three lawyers said they're moving for a mistrial. The second day, they amended that at page 670. My application is to terminate the trial with prejudice on behalf of Mr. Alvarez, simply because we painstakingly picked this tribunal, and this goes to Judge Gish's point. We liked the tribunal we picked. We didn't do anything that would cause the termination of this trial. The blame rests solely with the people. And then again at page 672, the last thing that defense counsel says to the court, in this particular case, it's my opinion, the only proper route is a mistrial with prejudice. Termination of the trial with prohibition against retrying the case against these three defendants. And then the last sentence, I would ask respectively that you declare a mistrial with prejudice and dismiss the indictment. There's nothing unclear about those statements. Thank you.
Thank you. Thank you all. The next case for argument is New Chapter Capital versus Carambellas. You may proceed, Counselor.
Good afternoon, Your Honors. My name is Stuart Shaw. I represent the appellant. I'm suffering from a bit of laryngitis. I trust my voice will carry to the bench effectively. Having said that, I will hold out as long as I can, and if necessary, I'll submit at some point if I can continue. Appellant is brought before the court this afternoon asking that it reverse the lower court in dismissing its complaint on a motion for summary judgment and/or a 3211 motion. There are two salient points which I wish to, with the court's permission, lead off with. And that's the contract in issue was an unusual contract. My client, in effect, purchased the proceeds to an ongoing divorce for which she received a fee at that time. The first error that the lower court made was that it completely ignored the legal implications of paragraph 12 of the contract. Paragraph 12 of the contract expressly provides that if there is a death, the obligation which has not been fulfilled be the obligation of the estate. Now, what obligation are we talking about? We're talking about the obligation to pay, in effect, the purchase price to my client if there were no proceeds
Counsel,
from the divorce.
In paragraph 12, doesn't it also go on to say, shall remain an obligation secured by any proceeds? It specifically says that. And then inside that same contract, it defines proceeds as a total recovery from the claim. Had there been any recovery from any claim here?
I'm glad that question was asked. It was one that I pondered for a long time about. When I went to law school...
Counsel, is it a yes or no? There are no proceeds from the divorce.
There
court,
was
correct?
no proceeds, but I respectfully submit the absence of proceeds is not dispositive without looking at paragraph 12, which contemplates no proceeds. Now, it's clear.
Didn't Judge Borak interpret paragraph 12, not to say that there were no proceeds, but rather that the proceeds had not been received by the decedent before he died? That's how he interpreted paragraph 12, and it seems to make perfect sense within the context of the entire contract.
Well, no proceeds could be received because there was an intervening death which terminated the divorce proceeding. And that's an excellent question.
Well, the
And
estate
that
would be
was-
entitled to the
that-
proceeds at that
And
point.
that was within the contemplation of the parties at the time they executed the contract. How do we know that? Because Judge Borak, in looking at my client's affidavit, totally ignored the fact that her affidavit establishes that it was the intent of the parties that there be no windfall to the estate, and that if there is an intervening death which prevents the realization of proceeds, under those circumstances, the money would have to be paid back to my client. Now, I believe,
I'm just not sure where you find that in paragraph 12.
pardon me?
I'm just not sure where you find that in paragraph 12.
However-
Here what happened, that is that this divorce action, as a matter of law, abated by death. So there were no proceeds. This paragraph 12 talks about proceeds. It doesn't say in the event of no proceeds, that the obligations, all of the obligations under the contract shall remain an obligation of the estate. You know, and in fact, you're not looking to recover proceeds. All you're looking to recover is the monies advanced, right? You're not looking for proceeds. There are none.
That is correct. But
Where does it say that the obligation of on the estate shall remain to return the money to the owner of proceeds? I guess that's really what I thought Judge Borak was kind of looking for,
Well,
and what I myself am looking for. That's what I don't see here.
Well, it says in paragraph 12, and I'm reading, the amounts due under this agreement shall remain the obligation secured by any proceeds. And then it continues in the disjunctive. And this agreement shall be binding upon the seller's estate. Now, paragraph 12 doesn't even discuss proceeds.
Well, but they can't actually be read disjunctively, because the only monies we're talking about here are proceeds, and that the proceeds is binding on the seller's estate. We're not talking about anything else here.
With all due respect, paragraph,
I'm respected. Just explain to me your argument.
the argument is very simple. When this paragraph is read together with paragraph 4, the intention of the parties must be ascertained. The second error that Judge Borak made was there was an affidavit submitted by my client after consultation with both attorneys who represented the
I'm
estate.
going to stop you there, only because your time is up, but that's a different issue. If the contract is unambiguous, if we believe it's unambiguous, then that affidavit, whether it should or should not have been considered, utterly irrelevant. All right, let's hear from your adversary.
Good afternoon, Your Honors. May it please the Court, Michael Lagnato for the defendant respondent, Andrea Carambellis. The agreement here specifically provided that the seller, in this case the respondent's decedent,
unconditionally and irrevocably grants, assigns, transfers, and conveys all or a portion of the seller's portion of the proceeds recovered with respect to the divorce claim. It specifically states that in paragraph 4, that the seller understands that by entering into this agreement, seller is selling purchaser a portion of the potential proceeds of the claim. It specifically states this is a non-recourse sale. This is not a loan. It specifically states, most importantly, in the event that the seller does not receive any award or settlement from the claim, seller will not owe any amounts to purchaser, and purchaser shall receive nothing.
And at the time of the decedent's death, had there been a judgment or any award in the divorce proceeding?
No, no. The divorce proceeding ended with the death of Peter Kaplan. No judgment, settlement, or any type of award had been made in favor of Mr. Kaplan up to that point.
Well, counsel, there are some provisions in the contract that your opponent points to show that there shouldn't be a windfall. And here, the sort of irony is that Mr. Kaplan was divorcing Ms. Karambalis, but she's going to keep this litigation funding amount that was given to her soon-to-be ex-husband before he died. So they rely, for example, on that guarantor, that guarantee, I think it's called the sweetheart guarantee, to show that there shouldn't be a windfall. Should we draw an inference from that this money should be disgorged?
No, respectfully, no, Your Honor. The difference, and Justice Barak pointed out that the sweetheart guarantee and the other provisions that would provide for proceeds in the event of no judgment or settlement of the divorce action, the difference was that those provisions provide for acts that were voluntary. If there was reconciliation between the parties, if there was voluntary abandonment of the divorce action, if there was a mediated settlement. The difference here is those are scenarios that would have been in the control of Mr. Kaplan. They were voluntary as compared to his death, which was not. And again, the contract specifically provides for the return of the money in those instances. It does not specifically provide for the recovery of the money by the plaintiff in the event of death. There's a specific provision, that's paragraph 12, and paragraph 12 is contingent upon amounts due under this agreement. And under this agreement, there were no amounts due at the time of death. With respect to the issue of the Noonan affidavit, as Justice Gish points out, given the finding of Justice Barak that this was an unambiguous contract, a finding that is well supported by the language of the agreement, that affidavit is irrelevant. It's parole evidence. It's also inadmissible hearsay, and the court.
Inadmissible hearsay is allowable to defeat summary judgment, and that as long as it's otherwise corroborated. So that that the hearsay aspect is not as troubling as the fact that it may in fact be just simply irrelevant.
I don't necessarily disagree with Your Honor. With respect to the hearsay, under certain circumstances, the hearsay affidavit might be admissible, but as Your Honor points out, if it's corroborated.
Admissible is not the right word. It can be submitted in response to a summary judgment motion to defeat summary judgment.
Correct, but here it's uncorroborated, and even the substance of the affidavit talks about the understanding of an attorney. It doesn't indicate that the attorney ever communicated that to Mr. Kaplan, or that Mr. Kaplan, who actually signed the contract, understood that as well. If there are no further questions, I have nothing further. Thank you, Your Honors.
Okay. All right, some rebuttal, please.
Briefly. I have fully noted the comment from the court that the affidavit in issue is irrelevant. It's highly irrelevant because A fair reading of paragraph 12, at the very least, shows that it's ambiguous. It says, if seller shall die before receiving recovery and before the purchaser is paid, the debt will remain the obligation of the estate. Judge Borak, to make paragraph 12 meld with paragraph 4, engrafted upon that paragraph words not contained therein, the word judgment, the word investment contract. So I respectfully submit, at the very least, there is a question of fact and a latent ambiguity to make sense of this contract so that there is not an utter unintended windfall to my adversary's client. And that was the purpose of the affidavit. And as the court properly
Was it
pointed...
corroborated?
Pardon me?
Was it corroborated? Uncorroborated hearsay can't defeat summary judgment. So it would need a modicum of corroboration.
With all due...
Stop with all due respect. I'm respected, okay? I like that. I'm respected.
Pardon me.
So I'm asking you, assuming that we agree with your argument that this is ambiguous and that we can accept parole evidence, in order for us to consider the affidavit, it would have to be corroborated in some respect. Was it?
With all due respect, Your Honor.
Stop, please. Honestly, I mean it. You don't have
I
to.
promise you I won't make that mistake the
feel
third time.
respected.
The
I
point that
respect you do. Go ahead.
The point that I want to make
Yeah.
is that I am aware of no case in this court or any other court that we've researched that requires more than an affidavit contesting the issues. And if it's hearsay, it is sufficient alone without corroboration.
Okay, we'll look into that point of law. I'm
Thank
not
you.
sure that you're right on that, but we'll look into it.
Thank you very much, Your Honor.
Thank you. Okay, the next case for oral argument is Montague versus T&W Restaurant. Okay, you can proceed, Counselor.
May it please the court, Michael Zhu, of counsel to Dubose, Smith, and Morathi, on behalf of the plaintiff appellant Antoinette Montague. We believe that the trial court erred in denying plaintiff's motion for partial summary judgment as to liability. In this case, where an employee of the defendant admits at his deposition that he went down the wrong way of a one-way street. That's in violation of VTL 1127A, which establishes plaintiff's prima facie entitlement to judgment as a matter of law.
Well, I think one of the issues that opposing counsel raises is that your client came out between two parked cars, and that was against the VTL also, or against some regulation also?
Well, yeah, the defendant's opposition to the motion, he doesn't dispute that he went down a wrong way.
Right.
What he says is that the plaintiff crossed not at a crosswalk in violation of New York City traffic rules. The problem with that defense is that goes to her comparative negligence, which is not an issue because the plaintiff never moved to dismiss the affirmative defense of comparative negligence. She only moved for partial summary judgment as to the defendant's liability. And this court recently I'm sorry, I lost track. This court recently in Benny versus Concord, that's at 189 to 83D 572, says that plaintiff has two burdens in moving for summary judgment. Plaintiff has two issues. One, she doesn't need to establish her freedom from comparative fault. And two, there's no burden on the plaintiff's part to establish that the defendant's negligence was the sole proximate cause of the accident. Now, as we know, there can be more than one cause of an accident. The fact that the plaintiff may be comparatively negligent in crossing not at a crosswalk doesn't refute her argument that the defendant violated the VTL, which establishes his negligence.
Right, one thing though, when I was reading the lower court's decision, the court seemed concerned that while you cited to the provision that established the negligence of the cyclist, you didn't prove causation, or that it was a proximate cause, not the collateral issues of comparative and sole, that you didn't, there was nothing in this record to show that this was a cause. Is that true?
No, because the plaintiff testified that she looks one way, the way that the vehicles are traveling, and seeing that she lets one car pass, and then sees a car at the corner, and then steps into the roadway.
So she
doesn't have a duty. She doesn't have a duty to look the other way because...
Yeah, she had a description of the accident.
Right.
That was sufficient enough to at least provide a basis for causation.
Correct.
This wasn't a complicated causation issue.
Right. She steps into the roadway and gets hit by the bicycle.
She has no duty to look both ways?
I'm sorry?
She has no duty to look both ways. Is that what you're saying?
Correct. Under this court's precedents in Bennett versus Cruz, 168-82D-307, where this court held specifically that a plaintiff doesn't have a burden to look in the opposite direction of where vehicles are coming from because there's no expectation of a vehicle coming from that direction. And here the plaintiff testified that she looked left. She actually did look left, but never turned back right. And she said, why would I? Because I'm not expecting cars from coming from that direction.
Yeah, I was going to say, she actually testified that she did look both ways.
She did look both ways, yeah.
But the testimony from the cyclist was, the delivery person was clear that he was traveling in the wrong direction, in the opposite direction of traffic.
Yes, he admits that, yeah.
So, I mean, the point by Supreme Court was that you did not establish that she was not the proximate cause of the accident. But even if she's jaywalking, is there any way to say that she would have caused the accident?
Well, no, first of all, I don't think she's jaywalking because the bicyclist doesn't have the right of way. You violate 4-04C3 when you cross a street, not at a crosswalk, and in this instance, if the car was coming from her left and she gets hit by the car, that's comparative negligence.
Does it even, does it matter? Because all that goes to is comparative negligence.
Right, yeah.
What did she do that was a proximate cause? We don't need to even find that out because you're going really under a Rodriguez theory, just on liability of the defendant here.
That's correct.
Right.
Yes.
Okay.
Thank
All right, understood. All right, let's hear from your adversary.
Good afternoon, Your Honors. May it please the court. My name is Jay Ju. I represent the respondent, T&W Restaurant, in this matter. It is our position that the lower court did not err. Proximate causation is an issue of fact here. Both parties.
Why? Why is it an issue of fact regarding your client? The description of the accident is pretty straightforward. There aren't complications about whether your client could have been a proximate cause, not necessarily the sole, but a proximate cause. He's going down the wrong way. That's negligence. It violates the statute. He hits her. Where is the causal break?
Well, she's also violating the law.
Maybe so. That's comparative. I just want to look at your client's behavior right now.
Well, my client is traveling in the opposite direction, but she emerges of two vehicles and did not give...
That's her comparative. Unless you think that there's an issue of fact about whether she's the sole reason for the accident.
Yes, I do believe that. I mean, if she is crossing...
Based on what? Based on what? Are you saying that when she crossed, that, her injuries were the result of her tripping in a hole? That she fell in a hole or a manhole or something of that nature? I mean, based on what?
Well, a jury could see that she should have looked... She looked to the right, she looked to the left, and she should have looked to the right again. And if she did look to the right again,
She
would have
she
observed
should have
my
looked-
client-
He should have anticipated your client riding his bicycle in the opposite direction of traffic?
Not anticipating, but she also has a duty of not, if she is going to jaywalk, she has a duty to make sure the traffic cleared in all directions.
Wasn't there a bicycle lane on this street?
There was, Your Honor.
Well, was your client in it?
I do not believe so.
Well, it doesn't matter if he was in the bicycle lane or not, because he was still going in the wrong direction.
Well, she's also jaywalking, though. That is the.
That's the whole
that is the
concept
point
of comparative negligence and more than one proximate cause. I mean, this sort of fits within our paradigm of how we look at negligence.
Well, it is our position we should be able to argue in front of the jury that she could have been the sole proximate cause of her own accident, because they're both violating the law here. She's violating the ordinance and he's violating the VTL. So
Did she hit him, causing his injury, or did he hit her, causing her injury?
well, that's why it should be presented for the jury. That's not something that can be determined as a matter of law.
Really?
And as to the vicarious liability, it should be noted that plaintiff did not sue the employee directly. So in order to have vicarious liability, it's plaintiff's burden to prove that the employee was under the scope of employment.
He said he was going back to the restaurant in order to deliver the receipts from that night's deliveries. And he was
Yes,
trying to
but-
get back to the restaurant prior to their closing.
Yes, he's doing that on his own. An argument can be made, and the jury could find that he's doing that for his own personal gain, because the restaurant never instructed the employee to come back as soon as possible. The restaurant never said you should violate the VTL.
He works for the restaurant.
Yes, plaintiff is only hurrying, violating the law, only so that his coworkers would not be upset, because they would have to wait for him. So that's not necessarily furthering the restaurant's business.
He has to return the receipts to the restaurant. It's the restaurant's money, is it not? So he has to return those receipts to the restaurant so they can clear up whatever business they have to clear up.
But argument can be made that, does that mean that you should violate the VTL? No one told you you have to be there at a certain time. Does that mean that you have an interest to violate the law, to ask the employee to violate the law? There is no instruction. The manager said specifically that.
I think you're conflating things. He was operating the cycle within the scope of his employment, because that's how he got back and forth from deliveries. The fact that he was violating the law doesn't take it outside the scope of employment. If he was, I mean, we've held that a million times, not with necessarily a bicycle, but, you know, in terms of that scenario.
Well, I mean, I think
You don't need the employer to tell you, you are not acting for us if you violate the law, the traffic laws. That would not make no sense.
Well, if there's case law that says if the employment acts are personally motivated and unrelated to the furtherance of
Well,
business.
I couldn't be more related. Okay, let's hear from your adversary.
I actually think the court has the argument, so I'm going to waive my rebuttal time. Thank you.
Okay, thank you. Okay, the next case for argument is Spicer versus Garda World Consulting. Excuse me.
Okay.
Okay, you can proceed, Counselor.
Thank you, Your Honor. And good afternoon, Your Honors, and may it please the Court. Michael Richter on behalf of Appellant Garda World. Your Honors, the Supreme Court abused its discretion by severing the plaintiff's claim from Garda's pending fraud counterclaims, because that claim and our counterclaims are inextricably intertwined. What happened here is the plaintiffs won summary judgment on a claim that, if ultimately upheld, will force Garda to make a $70 million earnout payment pursuant to a very complicated purchase and sale agreement. But Garda's pending fraud counterclaims arise out of that very same transaction, that very same contract, and concerns precisely the payment that
Counsel,
plaintiffs seek.
after Supreme Court granted summary judgment, then you entered into the stipulation in November 2018, correct?
That's correct, Your Honor.
Wouldn't it have been the easiest thing in the world just to mention the counterclaims in that stipulation? And isn't the silence of that stipulation concerning the counterclaims just fatal to your argument?
Your Honor's right. The counterclaims had been out there for over a year before the parties entered into the stipulation. But what the stipulation says is that there has to be, quote, a final determination. Now, that's defined as a final determination of the declaratory judgment claim in the Spicer action, but that the stipulation in paragraph 9 of that, and that begins at the record at 109, Your Honors, paragraph 9, is under New York law. New York law, the Constitution of our state, sets forth the doctrine for finality. We didn't waive the finality requirement under the New York State Constitution, so that final determination language is accurate. And it's also, Your Honor, it's in the very structure of the stipulation. We are only permitted to make a single payment to one person of $70 million. There's no way to break it up. And we also have very specific language in paragraph 2G of that stipulation about the set-off. It says, notwithstanding any terms to the contrary in the PSA, right? It doesn't say anything about the counterclaims there. So that's something we preserve. But the problem here is if the Supreme Court's decision is not reversed, then we could be in a world where Garda pays $70 million for an earnout that's been procured by fraud. We have very serious fraud counterclaims supported by documentary evidence that they left behind after we bought this company. We've survived the motion to dismiss on that. 10 depositions have been taken. 500,000 pages of material have been exchanged in discovery. So if Garda is right, if our counterclaims are correct.
Can I stop you for a minute? Because this presumes that the only remedy you have is a remedy of set-off on the fraud. And I don't see it in the stipulation, quite frankly. But leaving that aside, the idea that you're going to be remedyless is not really true. You can get a money judgment for fraud based on fraud damages. And then, in fact, because there seems to be a lot of money floating around there by the alleged fraudsters, they are not judgment-proof. So I'm not really sure, what is so dire about this procedural context, which seems to be the context that you bargained for.
Well, here's the risk, Your Honor, and it's actually the context we exactly bargained not to have. All of the defendants, all the counterclaim defendants are foreign. We've discovered in our depositions now that they have absolutely no assets in the United States. So we knew that before we took their depositions. That's why we set up a stipulation that we would not have to make a payment until there was a final determination.
Well, why weren't you clear about that?
I think, every lawyer, when there's a dispute about a contract, wishes they had added a few more words to it. But we thought we were.
These are not just a few more words. This changes the whole nature of the obligation.
Especially since you're stating that you knew the issues as to the counterclaim. I don't understand why, based upon that, again, you would not include that in the stipulation.
Your Honor, they knew about the counterclaims too. They could have said, but this doesn't include the counterclaims, and we're trying to create some sort of exception to the.
Why would they do that when you didn't impress your own rights there? For goodness sakes.
It says.
Stop that. Okay, let's deal with your real arguments.
Okay. Well, again, going back to the severance, right?
Okay.
Sorry, Your Honor.
No, go ahead. Go ahead.
The law is very clear. I mean, the cases that both parties cite is the question is, are the claim and the counterclaims inextricably intertwined? Right? And, Justice Mazzarelli, your decision in News Limited versus Australis, that's 293 AD 2nd, 276, explains that standard. What you wrote there, Your Honor, was, quote, severance was also properly denied given the substantial overlapping of respondents' claims against appellants and defendants, all of which arise out of closely interrelated contracts, plural. Here, we don't have multiple overlapping contracts. We have one transaction, one contract. It's the source of all the disputes between the parties, and it all pertains to one thing, how
We
much...
didn't have a stipulation in that case.
No, there was not a stipulation in that case. But I don't see how the stipulation... Sorry, Your Honor.
No, go ahead.
It's a little tough with the math sometimes.
I know. It makes it very difficult to communicate.
I don't see how the stipulation... Can I continue?
Yes, you may.
Thank you. I don't see how the stipulation changes what the legal standard is for severance. Obviously, they have a
It
position...
doesn't change the legal standard, but it does change some of the facts that we have to consider.
I think it's a separate issue, right? The stipulation is just whether or not there's a final determination and whether or not we have to make a payment. Both parties got something and lost something in that exchange, but it doesn't change whether or not severance was properly granted.
Okay. Thank you.
May it please the court, my name is Sandy Lipak, and I represent the 7 plaintiffs, the sellers, as well as the 3 counterclaim defendants. We come to agreement that the issue here...
Well, if we accept your opponent's argument that the disputes here are involved in one contract and the negotiations for the contract and what they allege to be fraud during those negotiations, why aren't the counterclaims why are the counterclaims subject to severance?
Yeah, the counterclaims are really very different, totally different from the main claim. The main claim, as your honors will recall, because we were before you, was a contract claim, a declaratory judgment action, asking what a particular phrase in the contract meant. What was the earn-out period? What was the measurement? That was all it's about. The counterclaim is totally different. It's a claim that 3 of the 7 engaged in a fraud by delivering false financial statements of a subsidiary of the company. Those are 2 different claims. One's a tort,
Did the court
one's a contract.
I'm sorry, I interrupted you.
I'm sorry.
No, did the court sever as to all of the defendants, or did it sever only as to those?
He severed it as to all of them, because he severed the claim. He didn't sever it as to parties. He severed the claim. What he said is, here is a claim, a declaratory judgment claim, which has been pending for 5 years, which this court granted summary judgment on in 2018, which the Appellate Division affirmed in March of 2020 unanimously, and I have a counterclaim, which is a tort claim against only 3 of them. It is a totally different claim. It involves issues, as your honors well know, of scienter, of what was the financial misrepresentation, of damages that flow, totally different. And so what he said...
Yeah, well, is it really totally different if, in fact, the fraud pertains to the underlying contract that you were trying to get an interpretation of in the declaratory judgment action? I mean, isn't there some connection or relationship between them?
In the broadest sense, yes, because, as you just accurately point out, the contract is the starting point. But it's not enough that there's some relation. They must be inextricably intertwined. And the court said here, they are not. And by the way, and it's not irrelevant in my judgment, this judge has supervised this case for the last 3 years. Next to counsel, he probably knows it as well as anyone. And when he says, and I quote him, these claims have absolutely, declaratory judgment action, which has been entered for almost 3 years, has absolutely nothing to do with the counterclaims in this case. And he was right. He's absolutely right. And what he said is, it is time to move on. You know, he saw this for what it is. We got summary judgment 3 years ago. One of the plaintiffs has died. The other 2 are elderly. We're talking about an agreement that we reached, by the way, as you pointed out, while this case was pending in this court, which said, if there's a final determination, not of the case, of the declaratory judgment claim, if there's a final determination of the declaratory judgment claim, we'll pay you. So this court affirmed. They asked this court for the right to ask the Court of Appeals. The court declined that motion. Did they go to the Court of Appeals? No, of course not. They did not. So here we are 2 years later. We said to them, go to the Court of Appeals if you think you're right. No. Then I said to him, well, we're going to move to sever. Why won't you agree? Because then you can take that claim right up there. No. And Justice Borak saw it for what it was. He said, you're stalling. You got $70 million interest-free that you're holding on to. And meanwhile, I've got plaintiffs who are dying and elderly. Now, they criticize him, and I must say, they criticize him for taking into account the fact that the plaintiffs, many of them, are elderly, and one has passed away. He had every right to do that. That's what's called discretion. There's no question he had the discretion, and he properly exercised it. And by the way, if he had denied the severance motion, I would be here telling you that's an abuse of discretion. Holding the 7 plaintiffs hostage because you got a claim against 3 of them? That's unthinkable. I want to end by saying one thing, this court. This case has dragged on and dragged on. We've had a judgment. We've had it affirmed. We've gone back. We're back here. The late Judge Gerfine once said it well. There comes a time to apply the well-known doctrine of enough is enough. It's time to move on. They want to go to the Court of Appeals, they got the vehicle to do it. If they don't want to go to the Court of Appeals, hey up. That's what this is about. Thank you, Your Honors.
Thank you. All right, rebuttal, Counselor.
Thank you, Your Honors. Your Honors, the counterclaims are not different. They all impact the consideration that is due. That consideration includes the earnout. That's why we have to look back at what this is about. Yes, their summary judgment win so far is about the interpretation of a provision in a contract, but the meaning of that victory is that they get paid on an earnout. That earnout is the subject of our fraud counterclaims. That's exactly why they're inextricably intertwined. And there's a number of cases that make that point. And we cite them in our reply brief, Your Honor. That's docket number 8. Just one example, Busher v. Galbraith, that talks about arising out of a single transaction. That's our situation. So the fraud pertains to the underlying contract here, the earnout. Now, I have to respond to this point about the stalling and the delay. You know, it's in our papers, and I don't want to belabor it. But if anything, we've been trying to accelerate this. We're plaintiffs in this case, too. I assure you, Garda wants to get paid as soon as possible on its counterclaims. We agreed in the stipulation to dispense with a completely second lawsuit that would have been necessary for them to get 40 of the $70 million. We also agreed to dispense with an accounting referee who would have had to analyze a whole spate of separate issues that are now out of the lawsuit. So really, I just have to react strongly to the notion that we are delaying here. That is not correct. So I would just end, Your Honors, with this really is all about what does Garda have to pay the sellers, the plaintiffs in this action. And they say we owe them an additional $70 million. We say that earnout, which triggers that obligation, which has targets, thresholds, amounts set forth in a complex purchase and sale agreement, that's what was procured by fraud. Thank you, Your Honors.
Thank you. Thank you both. The next case for oral argument is Brayengard against KSSNY, Inc. All right, we just have the respondent, correct?
That's right, Your Honor.
Okay, go ahead.
Good afternoon, Your Honor. May it please the court. William Craze with the firm of Porzio, Bromberg, and Newman on behalf of the plaintiff respondent. We are asking this court to affirm the trial court's denial of the defendant's motion for summary judgment. The defendant argues that the plaintiff speculates as the cause of her trip and fall accident, and as a result, the defendant is entitled to summary judgment. Frankly, they are wrong about that on both counts. There's no dispute that the day before this accident, the city was hit with a blizzard, which dropped 5 inches of snow on the city. There's also corroborating evidence that there was 8 inches of snow on the ground at the time of the plaintiff's slip and fall. Plaintiff testified clearly that there was snow, ice, and water on the sidewalk outside the hotel where she was staying. And when she returned that evening, she had walked through that snow, ice, and water to re-enter the hotel. This testimony is corroborated by certified weather records. The defendant offers a witness who denies that it was wet outside at one point in his testimony, but at another point in his testimony admits that he does not recall what the weather condition was like on that day. This alone creates a dispute of fact and mandates the denial of summary judgment, as Justice Freed had noted. As I noted earlier, the plaintiff walked across the snow, ice, and water, had walked into the hotel onto the marble floor where there were no mats laid down. She took 2 or 3 steps into the lobby, and she slipped and she fell. The plaintiff's testimony as to the cause of the accident is not speculative at all, Your Honors. In fact, the reasonable inference is that the cause of the fall was the fact that the mats were not laid down. The defendants knew and in fact admitted that when mats were not laid down in inclement weather, that visitors to the hotel would slip and fall. They've seen that on occasion previously. They had a policy where they would lay mats down in the presence of inclement weather, and that despite the fact that there was inclement weather that day and the day before, no mats were down in the lobby. The plaintiff testified that the cause of the accident to her was obvious. This is her deposition testimony, and it was confirmed by an affidavit thereafter, that either snow or ice on her shoes had gathered as she walked across the snow, ice, and water on the sidewalk, and that there were no mats on the floor, so she slipped and fell, or that the floor was indeed wet before she had entered. So she candidly testified that she did not see any water on the floor, leaving the fair inference that the cause of the fall was the fact that snow, ice, and water had gathered on her shoes, and there were no mats laid out for her to wipe her shoes, and that's why she slipped and fell on the marble floor. Taking the evidence in favor of the plaintiff as Justice Freed was required to, she denied the defendant's motion for summary judgment. There's evidence here that the defendants not only created this hazard, but were aware of this hazard because they had known about the risks to visitors in the hotel when they don't put down the mats in the presence of inclement weather. There's ample case law cited in our brief, of course, to support this decision, and the case law was relied upon by the Justice Freed below. The evidence is that this hazard known to the defendants caused the plaintiff to slip and fall. At a minimum, there's a question of fact or a dispute as to material fact warranting the denial of summary judgment. As a result, Your Honors, it's our position that the trial court properly denied defendant's motion for summary judgment, and we respectfully request that this court affirm that order. I have nothing further to add at this point.
Okay. Thank you. Thank you very much.
Thank you.
The next case is Hutchison versus Kirsch. Okay, you can
Good
proceed.
afternoon, Your Honors. May it please the court, my name is Mark S. Grodberg. I represent the defendants, appellates in this matter. And it is submitted that the trial judge erred in the Supreme Court in deciding against summary judgment and or dismissal in this case by answering the following 2 questions in the negative. The first being whether or not summary judgment or dismissal was appropriate, where the plaintiff had admitted that she had no memory of the subject accident. And the second question is whether or not the court should have granted summary judgment or dismissal where the condition the plaintiff blames for her accident was not an actionable hazard. It was open and obvious, was not inherently dangerous, and violated no applicable codes, statutes, or the common law. It's submitted that the plaintiff...
Counsel, you got experts on either side, correct?
We do, yes. But
and then the photographs. You have the photographs which look scary to me. Why isn't that enough?
Because being scary is not, first place, a basis for negligence. The question is whether or not that particular area complied with the statutes, and it did. And
Wasn't one of the problems here about whether this was a commercial building and people shouldn't have been living there, or whether people were living there and it was a residential building, and in fact the loft was being used as certainly a place where the defendant and his family were sleeping, and it should have been compliant with those regulations?
First
Isn't
play.
that part of the problem here?
No, I would respectfully disagree, and the reason why is it's not about whether or not it was used on occasion, and he admits, the defendant or the individual who represents the estate admits that he did on occasion, but it was used as an office. It was the code that was applicable was for commercial or mixed use, and the applicable code sections are not based upon whether or not somebody occasionally uses their space to sleep, or it was not something that he used for his residence. His testimony throughout was that he on occasion while he was working there, or in some occasions when he was coming into New York City, because he lived upstate, he would stay there. But it was not a residential building, and pursuant to the
But he didn't say, gee, you can use it as an office. He said you can stay overnight there.
Right, but that still is not what the building code is based on. The building code is not based upon the way somebody may on occasion.
But wouldn't it be negligent to say you could use this to kind of stay overnight if it's a commercial space?
Oh, that would.
I mean, at least creating an issue of fact is all I'm saying.
I'm sorry, say that.
At least creating an issue of fact that you don't get summary judgment in your favor.
How would there be an issue of fact? Because to not only.
It wasn't being used commercially by the woman who he
But
invited
that has no
to stay
relevance to
there.
whether or not the condition they're complaining about is dangerous, defective, or violates any code sections. That has absolutely nothing to do with the building code. The building code does not make a determination based upon whether somebody occasionally uses it. But let me just take a step.
I mean, it does if it's going to be used for overnight lodging or someone is going to sleep there.
There's no allegation in any way that it's going to be it was used for overnight lodging. It was used.
She used it. He said he would stay there sometimes with his family overnight, and she said that she was going to be in the city to visit an exhibit or whatever. And the invitation to her was that she could use the apartment or whatever for sleeping overnight. And she said she was going to sleep there overnight.
Okay, none of these facts, even the way you present them, which are not actually what they're entirely correct, but none of these facts change the building code.
Okay, so let's leave the building code.
Okay.
What about the fact that he, as the landlord, right, does he not have the obligation to ensure that the premises are maintained and reasonably safe?
And they were. They were. Our expert says they were. But I really do.
And so this goes back to Justice Moulton's point. I'm sorry if if you're getting a little frustrated by our questions.
I'm not.
I apologize for your frustration.
I just wanted to
Please, with all due respect, this goes back to Justice Moulton's first question. You have experts, two different experts who are saying various things. So again, why would that not be a basis for a denial of motion for summary judgment?
I would like to address the fact that the condition that is alleged is neither a violation of a building code section, even the ones that are alleged by plaintiff. It's not a violation. Furthermore, the plaintiff stepped backwards into a hole, and then furthermore, there's no contesting what the cause of the accident was, because the plaintiff herself testified that it was her stepping back without looking. But more importantly, and that is that the plaintiff herself testified within 30 days of the accident that she had no recollection whatsoever of how the accident occurred.
You're talking about the medical records, right?
Yes, correct.
Okay, thank you.
And That has never been refuted by plaintiff, and that is an admission against her interest. And the subsequent testimony is, all it does is provide feigned issues of fact.
You said that she testified that she admitted that she stepped back into a hole. Should there be a hole in the premises, on the premises? Why is there a hole there?
Because it's the entranceway to get up to the space where she was going that she was also told not to go use, by the way. So, but the fact is that there's still nothing wrong with there being a hole. They're all over this city. There's plenty of people that have an access way up to a space like that. And the code section that governs it does not say that it's improper. In fact, it's not even designed as a, the allegations that are made by plaintiff's expert are, if in fact, based upon what you've asked me, if this is somehow deemed not a commercial space, even though the certificate of occupancy says it is a commercial space, somehow the building code should account for this one particular circumstance and provide that there should be railings around this area, which aren't even in the sections that they refer to. So, but most importantly, the plaintiff herself stated in her medical records repeatedly, and I would like to quote from them.
No, don't quote from them because we have the record and you're way over your time. Well, we'll look at them. You don't have to quote from them.
Okay. Well, I would like to just say to you that, that she clearly stated repeatedly in her medical records, numerous different providers, that she either had a seizure, which there are medical records that support that she's had seizures, that she either had a seizure, and then on that particular day, the records even indicate that there was likely the case, or that she has no idea what caused her accident.
All right, you'll be able to follow up on rebuttal. Thank you.
Thank you. Thank
Let's
you.
hear from
And
your
if I could just say,
No, you follow up
No,
on
I just
rebuttal.
wanted to respond to the
Follow
personal
up on
comment.
rebuttal. You are so over your time.
All right.
It's no disrespect to you. I'm just trying to control time, okay? I said it's no disrespect. I'm just trying to control time. So keep it in mind. We'll hear it on rebuttal. Let's hear from your opposing counsel.
Good afternoon, Your Honors. My name is Emily Kern from Godosky and Gentile on behalf of the plaintiff respondent. May it please the court, it is our position that there has been nothing presented here today or in defendant's briefing that would give any reason to disrupt or overturn the decision by the lower court that
Well,
denied.
assuming for a minute that this is a commercial space, all right, is there at least an issue of fact about whether it was a hazardous condition when it was provided to your client for staying overnight? Not necessarily, I know there's an issue of fact about whether she was supposed to go up into the crawl space with an attic, but I mean with a mattress, the loft space with the mattress, but leaving that aside, right? Was it hazardous?
So if I understand correctly, Your Honor, your question is, the question you're posing is whether or not the space itself was complying with the building code and was a dangerous condition? Because what?
Not necessarily, because, if it's a commercial space, then I don't think there is any issue about whether it's compliant.
Well, I think the issue here then would be whether it's been zoned for a commercial space versus what it's actually being used for. And I think that's really what goes down.
So your theory of negligence is that even if it's a commercial space, by permitting her to use it in a residential way or for overnight accommodations, that was negligent.
That is
part of
correct.
it.
Or at the very least, Your Honor, that there's a question of fact as to the negligence, and that's what we would argue in front of the jury, in which defendant would be allowed to present his proof to the jury as well, and there's no reason to overturn the lower court's decision that this could be a question of fact. But I think the lower court did get this point correct when it said, regardless of what this is and what it's supposed to be, as a commercial space, it was not used for those purposes, and it was not safe based on our expert the photographs, the plaintiff's testimony, it was not a safe space for what it was being used
There was no claim that stuff was actually being stored up there. Nobody saw anything stored. It was a mattress.
Correct. It was a sleeping space. It was used as a bedroom, essentially. The defendant testified at his deposition. He said, that was my bed. That's where I slept. He used the space as a living space. He had a living room. He had a kitchen. This was the sleep area. This was the bedroom. And this did not comply with the dictates of the building code for a habitable space. So whether the defendant, or excuse me, whether the space was zoned commercially, it was not being used for those purposes.
Counsel, what about the argument that your adversary makes that she did not know the reason why her accident occurred, that she said that in her medical records?
Well, I would address that. There are 2 points relating to that issue. One, I think any inconsistencies between what's stated in the medical records and what the plaintiff testified to at her deposition raises issues of her credibility. These are issues that could be resolved at trial by the jury and should be resolved by the jury. But in addition, the proof that was presented, we see cherry-picked portions of the medical records. The plaintiff spoke in hyperbole. I mean, this is the type of situation where if going forward, any time a patient says to their medical provider, it all happened so fast, you know, I don't even know what happened, it was so fast, that then prevents them from later clarifying their statements or testifying in a deposition with better specificity, and certainly doesn't mean that the plaintiff is not going to be presented with that issue at trial. It certainly doesn't warrant the grant of summary judgment. So in conclusion, I would ask that the court affirm the decision of the trial judge and deny the grant of summary judgment.
Thank you.
Thank you very much.
All right. We'll hear rebuttal now, 2 minutes.
First, I would like to address quickly what is considered cherry-picked, and this is what I did want to read to you before. This is a quote from her medical records. She thinks she may have had a seizure a month ago when she walked off a 14-foot ledge, but she said she does not have a clear memory of the incident. Another quote, of note, the patient is not quite sure how she walked off a ledge 1 month ago. She states that she may have been confused and then they had a seizure-like event at that time. She felt like she had an out-of-body experience at that time, end quote. The patient reports that she fell 14 feet from a loft approximately 1 month ago. She walked off a ledge and landed on her feet. She does not know what happened. Continuing with a quote, she does not know if she lost consciousness or not. She said she was alone when it happened. These are not cherry-picked statements. These are statements directly from her medical records given to her doctors who were treating her and trying to make a decision exactly how they were going to treat her because they later diagnosed her with a seizure. And that was in relation to this so-called accident. She had no idea of what occurred. That is stated repeatedly in her medical records. This is not cherry-picked. But more importantly, any other statements that she's made, she says she doesn't know what happened, and then during her deposition, she testified as to folding sheets over, which corner she did. It is completely, entirely the exact type of situation where this is feigned evidence provided just to offset a motion for summary judgment. This is like storybook example of a feigned statement after the fact. And with all, what I was trying to say before was, Your Honor, I wasn't saying that wasn't disinterested in answering your question. I just wanted to get to the point of what I just expressed. So I apologize if you thought I was being frustrated. I really wasn't. I just wanted to get to that point. Okay. That's all I was saying. Thank you very much for considering.
Thank you. Thank you both. Next argument is on People versus Minaya Rodriguez.
Good afternoon, Your Honors. Danielle Krumholtz for Appellant Elvin Minaya Rodriguez. Mr. Minaya Rodriguez's guilty plea should be vacated because it was not made knowingly, voluntarily, or intelligently. His repeated proclamations of innocence and deception, coupled with his agitation throughout the plea proceeding, as well as his post-plea statements to the Department of Probation, cast significant doubt on his guilt.
Counsel, was he reallocated at sentencing?
He was, Your Honor, but his reallocation was simply the exact same statement that happened at the plea, in which it was simply a one-word answer, a yes or no answer to the court's questioning, which was insufficient, did not qualify as a sufficient inquiry for the court based on everything that happened at the plea proceeding. The court
Counsel, you made reference to his statements that he was not guilty. Those statements in terms of how he came upon the package, someone giving him the package, or him not knowing what was in the package, those statements were not made at the time of the allocution. Is that correct? Those statements were made during some of the pre-trial proceedings, the pre-pleading proceedings?
They were made at the same proceeding in which he did end up pleading guilty, right prior to the allocution.
Was there a second call in between that time?
That is correct, Your Honor. There was a second call. The court did allow Mr. Minaya Rodriguez to speak with his lawyer.
Because the judge continued to tell him that if you are not guilty, then you should not plead guilty. You should go to trial. If you were not in knowing and unlawful possession of the package and therefore the drugs, then don't plead guilty, go to trial.
That's correct. The judge did inform him of his right to a trial, which the judge had a duty to inform him of, but what the court failed to do was inquire into the specificity of his repeated statements that were not couched in any legal statements, but it was clear that he repeated over and over again. He said, quote, "I cannot swear to something that is false. I'm a victim. I was deceived." The court had a duty, but failed in its duty to inquire just a little bit further into what exactly my client meant there.
And that's the point where the court says, you are in an unenviable position. I understand this is difficult. You should, maybe you want some time to think about it. And that's when there was that second call. And then the defendant came back and stated that he wished to plead guilty, right?
That's correct. But what the crux of the
So what is your argument is that once the defendant came back and stated that he wished to plead guilty, that at that point in time the court should not have accepted the plea?
We're arguing that the court should have just inquired simply a little bit further. There's no magical words. There's nothing specific the court was required to say. But in light of my client's repeated statements, vacillation, clear anxiety, all this was happening through an interpreter, the court had a duty to just one further question to specifically address that he was claiming that he had been duped, that he was deceived, that this was false. It was clear that he was under immense pressure to plead guilty. The court made very clear that should he go to trial and lose, he'd be facing upwards of 20 years in prison.
So the attorney's statements that he had spoken with him for 2 hours about the plea and that he did want to plead guilty, that was insufficient?
That was insufficient for what the court had an obligation to do. I'm not claiming anything regarding Mr. Minaya Rodriguez's attorney's counsel to him. What we're saying is based on the record before the court, the trial court did not fulfill its duty to make further inquiry under Lopez into that my client statements negating an element of the offense that cast complete doubt that he was entering this plea totally intelligently and knowingly.
What about the waiver?
The appeal waiver?
Yeah, because in the waiver, doesn't he also talk about it being knowing and involuntary, his plea being knowing and voluntary?
That's correct, Your Honor. But the waiver is something part and parcel to every plea that he was required to sign right before the plea. The issue here is a matter of due process. The waiver overrides that. I don't believe that the waiver somehow fulfills what the court has a duty itself to inquire. The waiver is something required by the prosecution. I would just add that at the August 3rd proceeding, The court specifically acknowledged that my client was somewhat equivocal, but instead of just making sure, just something a little bit further to ensure that he was pleading guilty intelligently and knowingly, addressing the issue of knowledge that he had negated to the Department of Probation, instead the court simply just asked a yes or no question again to the lengthy statutory language, which was insufficient for the court's duty under a long line of cases. So for all these reasons, we'd ask the court to vacate his plea.
Thank you.
Good afternoon, Your Honors, and may it please the court. Jillian Lewis for the respondent.
Counsel, to your adversary's last point, at the time of the sentence, the defendant was placed under oath, and he, based upon the statement made in the pre-sentence report, and the court asked him, was he in fact guilty, and also went through whether he was in knowing and unlawful possession of the narcotic drug. Is that correct?
Yes, he was re-questioned under oath at sentencing, and I submit to you that that was further inquiry above and beyond anything that the court was required to do. This court has held multiple times that under Lopez, statements made during a pre-sentence report are not, the court has no duty to inquire further for those statements. Those aren't under oath, and they're not the same as statements made in court. That has been found in People versus Rojas, People versus Sosa, and People versus Pastor. And Your Honors, as an initial matter here, defendant's claims are unpreserved. The proper procedure for bringing this would have been a 22063 motion to withdraw the appeal or to vacate the judgment pursuant to CPL 44010. And this claim does not fall into the Lopez exception because looking at the record as a whole, the inquiry here was proper. Justice Peterson ensured that defendant knew throughout the trial all of the things available to him. She told him the things that would be available to him if he decided to go to trial, and she told him the current offer on the table. And defendant here had not previously been convicted of a crime and took the opportunity to get a very light sentence, 1.5 years for having over 18 ounces of fentanyl, and took advantage of that opportunity in pleading guilty. He had the opportunity to work with his counsel and to speak with him for 2 hours prior to the initial time that he took the offer. And then he had another opportunity during a recess of the court to confer with his defense counsel and in making the decision to plead guilty. So we ask that you affirm the conviction. Thank you.
Thank you. You may proceed.
Thank you. I'd just like to respond briefly to 2 points that the people made. First, regarding that this court has held that post-plea statements don't require further inquiry. This case is different. This case, the post-plea statements further elaborated on my client's many statements made at the plea proceeding. So had he just made those statements to the Department of Probation and the plea proceeding had been as any normal proceeding, we would agree that no further inquiry under case law is required. But here, Mr. Minaya Rodriguez doubled down on what he had already tried to express during the plea. So the court did have a duty to inquire further. Nothing specific, no magic words, just a simple further question beyond the, did you on such and such date, and recitation of the statutory language.
What about at sentence where the court actually did say when you pled guilty, you were in fact guilty, or you are in fact guilty?
The court simply asked my client, it was a one-word answer, a yes or no. Are you pleading guilty to knowingly? And it was a long statement of the statutory language. I don't believe that is sufficient to address my client's multiple statements that he
But
had
the
been.
question at sentencing was, when you pled guilty, you pled guilty because you are in fact guilty. That was the question. So what other question should have been put to the defendant at that time?
The court could have simply addressed specifically the statement that my client made to probation and referencing the plea proceeding to simply ensure that he, at the time, that he knew when he picked up this parcel, that he knew what it contained. That's the element that is called into question here. He didn't knowingly pick it up because he tried to explain he had somehow picked it up under false pretenses or mistaken pretenses, that he had been duped or deceived. There was no inquiry just to ensure just a little bit that, no, he did in fact know what was in that parcel. It's unclear from this record, and the court had a duty to just make a little bit further inquiry. And for these reasons, it was not a knowing, involuntary, and intelligent plea. Thank you.
Thank you. Thank you both. Pedraza versus New York City Transit Authority. All right, Counselor, you can proceed.
Good afternoon.
Go ahead.
Good afternoon, Your Honors. Harriet Wong on behalf of Defendants, Cross Appellant, New York City Transit Authority. We are here today to ask this court to decide one primary question: whether the decision about the entry speed, institutional entry speed of subway trains entering stations should be decided by the legislatively entrusted planning body of the New York City Transit Authority, or whether that decision should be left to the fickle decision.
I know you raise a myriad of issues in your brief, including qualified immunity and governmental immunity, but I would ask you at least to, in the first instance, focus in on your claims that the jury verdict was legally insufficient or against the weight of the evidence. Tell me how.
Of course, Your Honor. Plaintiff presented an expert, Mr. Bellizzi, to testify at trial and to present their prima facie evidence. That testimony by Mr. Bellizzi contradicts the very pleadings that plaintiff presented in this case. In Pedraza, the notice of claim stated nothing about the institutional policies of the transit authority with regard to entry speeds of trains. It concentrated solely on the supposed negligent actions of the train operator. The complaint...
Well, and the train operator in this case was found not to be negligent, correct?
Correct, Your Honor.
And so there's no issue here, at least on appeal, of respondeat superior. That's not the theory of liability, is it?
There is a specific issue, because if the train operator had the discretion to operate at tunnel speed or any speed lower than that, which is the testimony at trial, and he was found not negligent for entering at tunnel speed into the station, how can the institution, who is responsible only by reason of respondeat superior, be found negligent when its employee was not negligent?
Well, doesn't it go the other way? Isn't there an argument here, and I thought you made this argument in your briefs, concerning a theory that the transit authority was negligent in setting a policy that, in fact, the entry speed at this particular Spring Street station could be 30 miles per hour, which he was doing?
You're correct, Your Honor. It could be. And
so then the question really becomes, is that, and that could be the only basis, really, that the jury found the transit authority negligent, because they couldn't find him negligent on respondeat superior, right? You can't. The operator wasn't negligent, so that theory's out the window.
But if we turn on to that theory, then what is that theory based on? The testimony of Mr. Bellizzi.
Okay, that's what I want to know. Tell me if there's a sufficiency problem with that.
Yes, Your Honor, there is a sufficiency problem, because Mr. Bellizzi testified as to a 15 mile per hour speed limit 50 feet back from the entrance of the station, based on nothing. It was not based on any policy, any regulation, any rule of any kind. It's just his opinion working backwards from the location that plaintiff's body was extracted from the tracks and working backwards regarding the speed of the train.
Some of his opinion was based on some facts that were in the record and was based on plans and charts that were provided by the transit authority. But was there any evidence that there was an industry standard by which to judge the question of how fast should a train be going under these circumstances?
Not by plaintiff. Plaintiff presented no industry standard, and defendants actually tried to present evidence as to an industry standard. Mr. Korak, who is a leading expert in the field nationwide, was precluded based upon plaintiff's motion in limine. The one industry standard relevant to this case was prevented from being presented to the jury. So even if we take away all the qualified immunity issues that are present in this case, and we look specifically to the facts of this case, plaintiff failed to meet their prima facie burden because they failed to present any industry standard, and the conclusions of their expert upon which the verdict entirely relies is based on conclusory speculations, not on any rule or regulation.
Thank you.
Thank you, Your Honors.
Good afternoon again. I'm Brian Isaac still. We have to understand what happened here, and I think, Judge Gish, you alluded to it. This station is not a normal station, and if you take a look at the history of this case, you kind of see what goes on. 1 month prior to the trial of this action, the Transit Authority brought what they called the 3211A7 motion to dismiss the case, which in actuality was a summary judgment motion that was untimely, talking about the De Leon case, which you know I lost in this court, so we know about it. The court said no. The thing is that in Turturro against the city, we now know that in order to get an immunity claim, you have to have a study that matches the plaintiff's theory of liability exactly, and there's no study.
So let me ask you a question, but is immunity different from the idea that I raised with your adversary about proving negligence by reference to an industry standard? Because even if we accept what your expert said, it seems to me that he established that if a train was going slower, that in these circumstances, this accident could be avoided. But does that in and of itself establish negligence by the transit authority? Because the only way to guarantee that no accidents happen at all is that you don't run trains.
The answer to your question is obviously no. What you alluded to, Justice Gish, deals with the issue of causation. But experts have to base their opinions on their experience. They have to base their opinions on facts, and that's what Mr. Bellizzi did. Let me remind you of the facts that he based his opinion on. This is the testimony of Mr. Rivera. He's the train operator, okay? And this is what he said. He said that the severe curvature to the right was so bad, and I'm quoting now, this is 87 to 88, that one can't even see the station because of the curve. You know from reading this record that there were cameras that were mounted on the side because the conductor couldn't see the station. Mr. Bellizzi's testimony, again, undisputed, despite the fact that in the prior motion, the Transit Authority submitted 4 affidavits from 4 experts who they chose not to call at the time of trial, suffering a missing witness charge with respect to 2 of them. So Bellizzi's testimony, and I'm going to give you the pages, the curvature was severe and began a car length before the entrance, 265 to 266. It created, I'm quoting now, quote, a restriction as far as you can see. That's 266 of the record.
Mr. Isaacs, how do you respond to the Transit Authority's argument that you have to look at the 6 train not in isolation, not at a single subway stop, but rather as part of a system, and therefore you need to look at an industry standard for how you run that entire system, despite the anomalies of the Spring Street station.
And my response to you, Justice Moulton, is that's exactly what the trial court did. My adversary's position in her brief, as you know, is that the experts were somehow precluded from testifying about the systemic way in which this would affect the station. That's not true. What the trial court did, and I think absolutely correctly, was said, look, you can talk about anything you want with respects to the 6th line, because that's what we're talking about. We're not talking about other lines, we're talking about the 6th line. You can raise any issue you want with respect to how this particular standard would affect the 6th line. They chose not to do it because they wanted to try to apply a very, very specific claim dealing with a very, very specific station to all the stations, and that was never our claim.
But can I ask you a question? I mean, getting back to my first question, well, you keep talking about the standard. What was the standard? Where was the standard derived from? You clearly had testimony from your expert that this accident could have been avoided by the train going slower. And I think, honestly, we don't, you don't need to know advanced physics to know that when a braking system in something that moves is going slower, you brake faster. That's just basic physics. But the question about what rate of speed is acceptable is really what I'm having trouble with, because under your scenario, what if the plaintiff had fallen at the 120-foot marker, right? And then under your client's scenario, even going 50 miles an hour would not have avoided an accident. So what is the standard for the speed of coming into a station or a station like this, or where's the standard? It's my question. I'm going to let you answer.
Okay, I figured you would. So I'm not saying that every single accident that happens at every single state, that happens at every single station is preventable. But what the expert did, and this is an expert who was a longtime transit authority employee, let's not forget, for 25 years, he was a transit authority employee. The transit authority relied on. What he said is, when you have severe site restrictions, you cannot adhere to a standard which says that you can go into that station at the regular speed, the regular entry speed, 27.5 to 30 miles an hour. And what he did was he reduced it based on that site. Now, we had a case because of the point where he fell. But if he fell 5 feet in front of the train, he wouldn't have a case. If he went into the side of the train, he wouldn't have a case. The Bradley decision from the Court of Appeals makes clear that experts can give opinions on good and accepted standards, even if there is no concrete standard adopted by the defendants, because their position is you never have to slow down the speed. No matter what it is, you can enter this station at 30 miles an hour, despite the fact that they knew you couldn't see a thing. And Mr. Belizzi's testimony is that in a straight station, which most of the stations are, you could see from one end to the other. So we know from Obie, we know from Soto, we know from Coleman, we know from Noseworthy was the case. The Transit Authority has an obligation to act and to adopt standards in a way that can prevent preventable accidents. Not every case is actionable, but here, where there's no contrary testimony whatsoever, where the Transit Authority wouldn't even submit to one single witness who could be deposed to show the fallacy of that claim, I think there's more than sufficient evidence to show, based on the Transit Authority's evidence, Transit Authority's witnesses, that going in at this particular train speed is improper, a violation of accepted standards, and that a lower standard was appropriate, here 15 miles per hour. And once we made that showing, my position would be, if there was a different standard or something to show that it wasn't there, Transit could have put on one of those 4 witnesses, or actually 7 witnesses who they didn't put on at the trial at all to refute that testimony.
Thank you.
Thank you.
Waddle.
I think, Your Honors, that plaintiff's counsel actually proves my point. If a plaintiff falls 5 feet from the entranceway of this station, they would have no case based on Mr. Belizzi's testimony. If a plaintiff fell 50 feet from the entrance of the station, based on the 15-mile-per-hour standard Mr. Belizzi testified to at this trial, plaintiff would have no case.
I just, if I may, I'm kind of puzzled at how the transit authority's standard could be that you can enter a station that you can't see at the same speed that you're going in the tunnel. What if there was a train stuck there?
If there was a train stuck at the station, that's what the signals are for. So based on our experts who were precluded from testifying about the system-wide runnings of the transit authority, these signals are the reason
But there
why
was no
trains-
testimony in the record about the signals.
Because our experts, our witnesses about signals were actually precluded, because the signal system is a system-wide standard.
Well, why were they precluded?
Because they would have testified about the system as opposed to just the Lexington line. Because all of our witnesses, whether it be national experts or
Well, did they offer to testify about the signals at that station?
The signals at that station are corrugated based on a system-wide determination. So all of the signals are run on timers, and they're run system-wide based on connecting stations. So there's no way to just limit a signal system testimony to just one specific line, or the curvature to just one specific station, because there are 50 other stations with deeper curves that have less sight lines than Spring Street, and our witnesses were precluded from testifying with regard to those stations. We were limited solely to this one station, and this honors this court's decision in De Leon and the Second Department's decisions in Chase, Santiago, and Stevens never restricted its qualified immunity decision to straight stations or curved stations. It was across the board speed policy decision that was entitled to qualified immunity. Thank you, Your Honors.
Okay, thank you. Okay, don't go away.
I'm not
because-
going away.
Right. Okay, 'cause now we're going to hear you on the Martinez case. Okay, go ahead.
Okay, good afternoon again, Your Honors. And on Martinez, the same issues of immunity apply. Here, rather than just being precluded from testifying about or presenting evidence about immunity, the court actually granted plaintiff collateral estoppel on the issue based on Pedraza, which makes no logical sense because this court and the sister courts in the Second Department have actually greater precedent and greater jurisdiction when it comes to setting a issue preclusion on this specific qualified immunity based on speed theory. And instead of relying on the appellate division's decisions granting the transit authority qualified immunity, the court granted plaintiff collateral estoppel on Martinez because of the verdict in Pedraza and the court's refusal to entertain the immunity issue in Pedraza. And just to jump into the specifics of Martinez, the plaintiff presented evidence claiming that collateral estoppel was proper because transit had a fair opportunity to litigate the case. But as we just discussed in Pedraza, we were precluded not only with regard to the industry standard.
Well, let's get to that, though. The fact that you may think that in Pedraza there were errors at the trial court level doesn't mean that when that decision becomes final, that it's not entitled, in an appropriate case, to collateral estoppel. You can't say, no, that judge made errors and it wasn't fair. Errors don't deprive you of fairness because you always have a right to appeal, as you've done here. I mean, the question is are they really the same issues?
Yes, Your Honor. Are they really the same issues, but we also need to be provided a fair opportunity, not just when it comes to minor evidentiary rulings, but what we're talking about is that transit authority was precluded from even presenting the immunity issue.
But you would be asking the court to collaterally say that the judge in the first trial should be reversed. That's not that judge's job. That's our job. If we reverse the trial, then maybe it's a different circumstance. There might be other reasons that collateral estoppel isn't a perfect fit here, but I don't get that argument, not one little bit. You can't collaterally attack the errors of the trial judge to say it wasn't fair because the judge made mistakes. That doesn't hold.
Even if we take that issue aside and say we can't attack Pedraza on the collateral estoppel issue based on the evidentiary rulings. We had presented sufficient evidence that this court, you're right, Your Honor, Justice Gish is very correct in that the appellate divisions are what is the court that determines the issue and whether or not it was properly determined. And in Martinez, we presented De Leon, Santiago, Chase, and Stevens, all of which held that our speed policy, institutional speed policy, with regard to entry speed of trains into stations was entitled to qualified immunity.
Well,
I'm sorry.
yeah.
You didn't plead qualified immunity in the Martinez case.
Our motion for summary judgment also asked to amend the pleadings to assert that as an affirmative defense. And in Martinez, we didn't plead qualified immunity only because the pleadings that plaintiffs served on us, the summons and complaint, never asserted that the speed policy was going to be challenged. So the court actually granted us the leave to amend the pleading in Martinez to add the qualified immunity as an affirmative defense. And if
And isn't that in and of itself a difference between Pedraza and here in Martinez? In Martinez, the court has to deal now with the qualified immunity issue, whereas in Pedraza, there was at least a fair argument made that because you didn't raise it, you waived it.
Well, in Martinez, yes, the qualified immunity issue should have been decided by the court, and it should have been decided based on the appellate division decisions and not on Pedraza. And in Pedraza, if we were not entitled to the qualified immunity, then plaintiffs shouldn't have been able to present the speed policy theory to the jury because it wasn't in their complaint.
Well, that's a different issue. That's different.
Because if the transit authority is going to be faulted for not having an affirmative defense in their pleadings for which they had no reason to assert the affirmative defense, then why is plaintiff permitted to present that legal theory that's not pled in their pleadings at the time of trial?
Okay, thank you.
Your Honor.
So, Your Honors, let me just get to the actual question that I think you asked. How do you have collateral estoppel? It's two requirements now, right? Under Bickler against Eli Lilly and Kaufman against Eli Lilly and the rest of the cases that have come down. You have to show that the same issue was decided and that the party to be charged with the collateral estoppel had a full and fair opportunity to be heard. I don't think you can make the argument that the TA didn't have a full and fair opportunity.
Also, Mr. Isaac, does the jury verdict have to be reduced to a judgment first? Is that also, which is not present here?
Yes, Judge.
Is that fatal to the collateral estoppel claim?
It isn't, and we cited to the Vavolino case, which said that where you're dealing with a ministerial entry of a judgment, you can have collateral estoppel even when there's no judgment. That was pleaded below, and that was also pleaded in opposition to the defendant's motion. So there is no difference. The fact that there's no judgment, that ministerial act does not preclude application of the doctrine from a technical perspective, because what you have is you have the same thing. And I would point out to the court that if you look at Judge Nervo's decision, he dealt with all of the issues. He dealt with the transit authority's issues regarding governmental function immunity, qualified immunity. He dealt with it all and said that they just didn't prove it. See, the problem here is they had the opportunity to put anything they wanted. They just didn't want to submit any evidence to cross-examination. I think that was the problem, and there's a reason for it. And let me suggest to you what the reason is. And I put it in the briefs in Martinez, and I put it in the briefs in Pedraza. It's the 6-inch rule. Remember, there was a time when this court, in a case called Glover, and the Second Department, in a case called Yard, said that the transit authority had discretionary immunity for 6-inch gaps between the platform and between the train. I ought to know that because, believe it or not, I lost Glover and I lost Yard. And then we find out with 4 case systems, Zilianos, Leon, Sanchez, that doctrine never actually was true. This court rejected that doctrine. So the notion that you can say, I'm looking at a case that was decided in 1990 with a straight-edged station that has nothing to do with this station at all, and we don't have a full and fair opportunity to be heard. That's just not true. They had every opportunity to be heard. They chose a trial strategy of not putting on the witnesses that they said entitled them to summary judgment or 3211A7 dismissal. And Justice Mazzarelli, you had asked a question of my adversary regarding what the limitation was. And I thought that my adversary said that there was a limitation to this station. That's not what Judge Nervo said. He said that transit authority could raise any argument, quote, with respect to the Lexington Avenue line. It's 42C and 43C.
That was my question, whether or not it was limited to the Lexington line.
I'm sorry, I didn't hear that.
That is correct. That was my question about the Lexington line.
Yes, it's the entire line. It's not the station. So they could put anything they wanted with respect to anything dealing with this line. What Justice Nervo said was, I'm not going to let you change to other lines. And there's a reason for it. Let me just flip the switch. I promise I won't go over my time. Let's say that at this station, the Transit Authority 5 years ago instituted a 15-mile-per-hour limitation in the speed. I have a case now at another station where if that limitation comes in, I would win the case. If I try to argue that the Transit Authority's institution of a 15-mile-per-hour limitation in this station was applicable to a completely different station, you better believe Transit Authority would be screaming bloody murder, and they'd be right. You can't compare apples to oranges. And that goes to this case. This is a very specific claim with a very, very specific station. The court properly awarded collateral estoppel here because Transit Authority had the opportunity to litigate the case. Their strategies are binding on them. There's no impediment to this.
But I understand their statement. It's not that it's the same speed for every station. It's the same speed as the tunnel.
Say that again. I'm sorry. I had a little trouble hearing that.
It's not the same speed for every station. That it's the same speed for the tunnel.
Correct.
That tunnel.
Right, and what
adjacent to that station.
Yes, and what Mr. Bellizzi said was that if that making the change to lower this speed to 15 miles per hour, 50 feet before, that's one car before, would effectively add 10 seconds to every run, which could be made up by simply starting the trains 10 sessions earlier. And he even went so far as to say, again, not contradicted on this record, that on this line, the maximum capacity for trains is 29. You'd reduce to 28, and if you just ran another line, you could be ahead of time. So I don't see under Bickler, Bickler and Kaufman, remember, Bickler was a theory of liability that hadn't yet been accepted, and the Court of Appeals said, look, you litigated it on that strategy, you had a full and fair opportunity to be heard, it's the same issue, this is exactly the same issue, it's the same station, the same expert. I think the court properly granted summary judgment on collateral estoppel. Thank you.
Okay, rebuttal.
I think plaintiff's argument tying together Pedraza's case shows that this is all speculation. Yes, Bellizzi says 15 miles per hour applies to Martinez as well. Why? Because he's 120 feet from that station. What about the other expert plaintiff exchanged in Pedraza? Berkowitz. He testified, or he submitted an affidavit that says 10 miles per hour, 100 feet from the station. This is exactly the core of what happens in a case like this. If we are allowing not the institutional agency or planning body that legislature entrusts to determine speed, instead we're going to allow paid-for-hire experts or lay jurors to determine speed, every single station based on the type of accident that happens.
Everything has to be reasonable here. If the transit authority said they could run the train at 90 miles an hour into the Spring Street station, that couldn't be allowed.
You're correct, Your Honor. If the determination was 90 miles per hour, that would not be allowed. And that's because there is a speed policy committee that actually reviews all of this. In Martinez, the plaintiff actually submitted all the evidence of what we do to prevent accidents of this kind, outlier accidents. We determined crowding on the platforms. We determined how to prevent outlier accidents by advertising, by posting signs with statistics of when passengers fall onto the tracks, what to do when passengers fall onto tracks, help points to allow for greater communication. All of these determinations were taken into consideration by the Speed Policy Committee when they came up with the policy determination of track of tunnel or normal speed pulling into stations. We're not saying that any speed should be allowed, but that the specific question here of whether or not the transit authority's policy protects a greater number of passengers while also fulfilling its obligation to meet safe and efficient rapid transit was weighed by the transit authority, and its policy was rationally based, and this court has already decided that there was a rational basis on it in the De Leon case. Thank you, Your Honors. Have a good evening.
Thank you. Thank you both.